Well, good morning, everyone.
Good morning.
I hope when I say everyone, that everyone is all present and correct.
Yes.
I've got a slight problem with my second computer on which the e-bundle is displayed. It'll take me just a couple of minutes to sort it out. So I must ask you to bear with me. Meanwhile, is our expert witness all set and ready to go?
He is indeed, yes.
Thank you. And we'll just mark time for a minute or two. Oh dear.
There appears to be an issue with my. Can anyone see me on the camera?
I'm afraid I can't see you, Miss Stewart.
Okay, I'll leave and then come back in again. Hopefully that will fix.
Okay.
Yeah, see, I've only got 1, 2, 4 active cases. None of them are this one. Which is strange because we are logged into the same current one.
Stuart, you're not mute.
Am I visible now?
You are, yes.
Right, thank you.
Well, I'm sorted out now, and we can get on. And I'll swear the witness and then put him in your hands, Miss Ahmed.
Well, before we start, there is a question I'd like to have in relation to the experts, if I may. Hopefully I won't hold you for too long. But you might recall on the first day, in the context of talking about the supplemental witness statements that were filed on behalf of Mr. Saxena and Mr. Al-Ali, it was raised with you by Mr. Kotig that there had been a supplemental expert report that was flying around on behalf of the claimant. And you'll also recall that I made a submission that there was an amendment and there was this report flying around, but that there had been no application to admit it, nor had there been any application made to seek relief from sanctions, because the first report that was filed on behalf of the claimant was filed on the 14th of November, and the supplemental report is dated the 21st of November. Now, over the course of this week, in the course of reviewing my cross-examination for the experts, it came to my attention that the supplemental report is already in the bundle. And so in my submission, we say that there's been no permission granted to amend the report. There's been no application for any late filing. And Your Lordship, what we say, I mean, I had to go back and then review my cross-examination in the context of the supplemental report. And so, having already prepared the cross-examination for the experts, we say that there is procedural irregularity by in the bundle at this late stage. And so, Your Lordship, I just wanted to mark that for your attention. I can take you to the supplemental.
Well, are you or are you not applying for this evidence to be declared inadmissible on the grounds that it's late.
I am, yes. That's
Right.
the application.
Ms. Stewart, what do you say?
Well, before Miss Ahmed jumped in there, I was actually going to draw attention to the amended report, which I think I drew attention to on the first day of trial, which was over 2 weeks ago. In essence, what the report does, it sets out some technical points, just some variations. If I could take you to this report, it's at 10.
It is in the bundle, apparently.
Yes, it's.
All right, yes, where is it?
We can see the variations at 10.331.
The first page is 10.330.
Yes, I've got it.
Now, so the first point I'd make is that the experts have had over 2 weeks to consider this. And these are points that the variations are points that they should, in my submission, have considered before. If I go to the first amendment, that's at 10.339.
Wait a minute. So these are amendments of the first or the reply report,
Yes.
are they? 339. Yes, I'm there. Yes.
And that amendment reflects the following: that when setting up a Trezor wallet, it's not mandatory to set up a PIN, although it is recommended that the person to the person setting up the wallet by the relevant software. So it comes up as a prompt that it's recommended. And this amendment arose from the reference in the joint expert memo to the buyer setting up the PIN. And there was, in fact, no evidence of this happening in any of the evidence. So the natural question was whether this was a mandatory step, and if so, who could have set up the PIN. So this is a technical point that goes to security. The next amendment is on 10.340. And this refers to
Yes, go on.
And this refers to an additional mandatory step in the setup of a Trezor wallet that ought to have been included in the joint expert memo. Basically, in our, Mr. McDougall says that after the mnemonic has been displayed, so that's the 12-word
Yeah, I know. Yeah.
The person setting up the wallet is required to verify the code. That's not optional. Now, this happens by the user being asked to enter particular words that appear, randomly selected words that appear in the mnemonic. And those randomly selected words can be taken from any of the 12 words in the mnemonic. So, for example, if it was, let's say...
Well, I think you're going on a too great a length, really. Just keep it really short. I understand.
The point is, this is a step.
Yes.
Mandatory step that goes to, we say it goes to the very setup procedure, which is or should be the focus of the expert reports.
Yes. Anything else?
The next point's 10.344. These amendments quite simply set out, as an expert should do, the basis of any factual assumptions.
Yeah.
So those are the amendments, that's it. So we say they go to the heart of the matter. They're required in any event. The experts have had over 2 weeks to consider these amendments, so it's really not understood on what basis these amendments are opposed, and it shouldn't. And of course, it should be. I would remind your lordship that this was all, like so much in this case, done at the very last minute.
Well, the basis of the objection is that it's late and permission is required, and it's said that this is a procedural irregularity of sufficient gravity to lead to a ruling that the report ought not to be admitted. Now, let me hear from the second defendant. What's your attitude to this?
Sorry. Hi, is that better?
Well, yes. Much
Okay.
better.
We joined the first defendant in bringing this objection, but we also want to raise to your attention the Part 31 grounds for seeking an amendment of an expert report, and those grounds are whether there are if there was no reason or new evidence that was presented to the expert that would justify this change. And as Ms. Stewart has brought us through these amendments, I think you can see that these are facts that were publicly available and able to be considered by Mr. McDougall much earlier, before the joint memorandum of the experts and also before the submission of his expert report. So we join the first defendant in the objection.
I take it that in order to be ready to advocate for this exclusion of the evidence, that you and your team have read this supplemental report.
Yes, Your Honor.
And no doubt Ms. Ahmed has, as it was implicit in her submissions. But I'm going to allow this evidence to come in. This is a matter which I think can be reflected in a separate ruling as to the cost of this matter. It is late, and I'm not satisfied that it couldn't have been dealt with earlier than it has been. But I think that the justice of the case requires that this evidence come in, and I'm satisfied that both sets of defendants have had a chance to digest what is in this report. And so I shall probably need to be reminded of this, but there will certainly be an adverse costs order against the claimant in respect of this this late evidence. Right.
Your Lordship,
yes.
We will be making cost submissions also in relation to the defendants' expert reports in due course.
Well, I'm not interested in that. I'm just interested in dealing with this at the moment.
Okay.
So let's get on with the evidence. I'd like to swear the witness. If you, Ms. Ahmed, if you could just elicit his name and his address and the like, and then I'll administer the oath.
Mr. Sibley, are you there?
Yes, I am.
Hi, apologies for the late start. I know it's very late where you are, so if I could just perhaps first ask you to bring up your expert report, please. It's at 10-213, 10-213. You have your expert report.
Okay, yes, I have it.
The 14th of November before you. So this was an expert report that you prepared, but can we have your full name, please, first for the court?
Paul Sibinek.
Can we have your professional address, please, for the court?
Like, what do you mean by that? Like, Mr.?
Well,
No,
let's
it's,
go to
your,
the page of
it's,
your.
it's where you reside, Mr. Sibinek.
Oh, okay.
Yeah.
I live in Coquitlam, British Columbia, Canada, which is a suburb of Vancouver.
Perfect. And Mr. Sibinek, if you'd like to go to 10-247, copy of your CV attached to your expert report. And we see your full name and the address that you've provided. And if we go to the page before 10-246.
Yep.
At the bottom of the page is your signature. Well, do you confirm that that's your signature?
Yes, it is.
And do you confirm that the contents of this report are true to the best of your knowledge and belief?
Yes, I do.
And you've also prepared a joint memorandum. If I could just very quickly take you to that.
Okay.
That's at page 10-1.
Okay.
First page of the document.
Okay, I'm just getting to there now.
Now, there's no statement of truth attached to this joint memorandum. Do you confirm the contents of the joint memorandum to be your expert opinion and true to the best of your knowledge and belief?
Yes.
I'm grateful. If you'd like to remain there, then.
Mr. Sibinek, have you given evidence before in any court proceedings or arbitration proceedings?
Yes, I have.
You have. Well, you're probably then familiar with witnesses being asked either to take a religious oath or to make a secular declaration as to the truth of their evidence. And what's
Yes.
your choice, a religious oath or a secular affirmation as to the truth of your evidence?
Secular.
Right. Now, will you listen carefully to what I say to you and answer the questions that what I say to you ends with? Do you solemnly, sincerely declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth, and the opinions you give are your honestly held opinions?
Yes, I do.
Thank you very much, Mr. Sibinek. Now, let me just say to counsel, we have got to make good progress today. I want the factual evidence, if at all possible, to be completed. That will involve finishing off the cross-examination of Mr. Malik and his re-examination, and then the cross-examination and re-examination of Mr. Turner. We've reached a stage in these proceedings where many of the matters have already been very thoroughly canvassed in cross-examination, and I shall expect the cross-examination of Mr. Turner to be very focused, and so you are under that instruction. Please bear that in mind. Right, enough from me. Ms. Stewart, you have some questions.
Mr. Sibinek, would you agree that in acting as an expert in these proceedings, you have various duties, and your duty, your overriding duty, is to help the court and to help the court solely on matters within your expertise and which the court has given you permission to opine on?
Yes.
And would you agree that your evidence should be independent and uninfluenced by the pressures of litigation?
Yes.
And that you should provide objective, unbiased opinion and shouldn't assume the role of an advocate?
Yes.
And that you should consider all material facts, even including those which might detract from your opinion?
Yes.
And that in your report, if you're not able to give your opinion without qualification, you should state that qualification?
Yes.
Right. Could you turn to 10.5, please? This is the joint expert memo.
Okay, yes.
We can see there at the top that it said that the Trezor device was intended to be utilised as a mechanism for ensuring that the Bitcoin were not exclusively controlled by the buyer nor the seller until the US dollars were confirmed into TABARAK's bank account. Yeah?
Yes.
And once the funds needed for the purchase of the Bitcoin were confirmed in an accessible bank account, the Trezor device could either be used to craft a transaction which transferred the Bitcoin to the buyer's own wallet, or the buyers could accept receipt of the Trezor wallet itself. So there's no dispute about that.
No.
Now, it's fair to say, is it not, that the Trezor wallet on the 3rd of February was supposed to be set up in such a way so to ensure, from HUOBI's perspective, that the Bitcoin transferred to the address associated with the wallet, which I'm going to call the address, couldn't be transferred to the buyer before the buyer's funds were confirmed into TABARAK's bank account.
That should have, yeah, that's correct. It should have been, yeah.
Yes. And so that if the buyer didn't pay, the Bitcoin could be sent back to HUOBI.
Yes, that would make sense.
Now, you've accepted that neither the buyer nor the seller should have control of the Trezor wallet. And yeah, that's in the memo.
Yes, neither the buyer or seller should have control of this. Yes.
And you've accepted that in the event that the buyer didn't pay, the Bitcoin was to be sent back to HUOBI. That the process had to allow for that.
Yes.
So therefore, as a matter of logic, would you accept that the only way that this process could work is if TABARAK had sole control of the Bitcoin in the address?
No, there's other ways it could have worked. There is, in the joint expert report, we discuss a way whereby TABARAK would have not necessarily needed to have received the Bitcoin in a wallet of theirs at all. So
I should have caveated that, assuming that a wallet was being used for holding the Bitcoin until payment had been made. In order to ensure that neither the buyer nor the seller should have control, and in order to ensure that also that the Bitcoin could be sent back to HUOBI, would it not be correct to say that the only way this could work is if, in relation to that wallet and in relation to the Bitcoin in the address of the wallet, TABARAK would have to have sole control?
A third party would, if you're using a trusted third party for, storing or holding that Bitcoin, that third party should have, exclusive control over that.
Yes, of course. Thank you.
Yeah.
Now, you would agree, presumably, that fundamental to understanding how the Bitcoin could be kept safe is understanding each and every step of the setup for a Trezor wallet. Would you agree with that?
Yes.
And this was a Model T Trezor wallet, yeah?
I forget offhand, but I'm not sure of the exact Trezor model, whether it was the Trezor T or 1.
Right.
I'd have to check my check notes.
Okay. Well, it was the Trezor T.
Okay.
Now, would you agree that the setup comprises, in chronological order, first of all, you have the new wallet, you remove the seal on the new wallet, yeah?
Yes. Well, after inspecting it first, but yes.
you plug the Trezor into a computer, and would you agree that if in this scenario, for security reasons, that this computer couldn't be for, a computer belonging to the buyer or the seller? It had to be, if TABARAK was acting as a trusted third party, it would have to be TABARAK's computer.
I wouldn't necessarily say that, because the seed phrase is only displays on the device itself, and one of the benefits of using hardware wallet devices is that you're immune to a lot of the type of malware or spying that a computer would have. So even if the computer was compromised itself, it could have still been okay. Not that you'd really want to use a compromised computer anyways, but
well, quite. Then we have the generation for the mnemonic, and you agree that the purpose of the mnemonic is to enable a user to access the Bitcoin in the address if for some reason the device is lost or it malfunctions.
Among other reasons, yes.
And so what happens then is that a record is taken of the mnemonic, and it's generally recommended that this is recorded in on paper form.
Paper or in some cases steel, but yes, it should be written down in and not stored digitally.
Right, and then we get to the verification process. Now, you will have seen from Mr. McDougall's report, and I'll just remind you at 10.281, would you agree that the verification step is a mandatory step in the setup?
Yes, I would agree.
And that this occurs straight after the mnemonic is displayed?
Yes.
And would you agree that the Trezor manual describes this process as follows? Carefully write down the words in the exact order they're presented. Once you've written down all the secret words, you'll be asked to enter a few randomly selected words from your 12-word seed on the touchscreen.
Yes.
So just for the assistance of the court, what or perhaps if you could agree with me, Mr. Sebenik, what the device says is give me the first word, give me the seventh word, and so on. Yes?
Yes.
Now, you'd also agree that these words are chosen at random, so they could be from the first 6 or the second 6 of a 12-word code.
Yes.
So you would agree that whoever carried out this verification process is likely, as in more likely than not, so a greater than 50% probability, to have had access to all of the 12 words of the mnemonic?
In all likelihood, the whoever carried out this verification process could have had access to the other words. Yes.
But in fact, it's more likely than not that they would have had access to all 12 words of the mnemonic. Simply
yes.
Mathematically.
Yes. I think that is the most likely scenario through Occam's razor. Occam's razor.
Well, actually, it's maths, not Occam's razor. But so on any analysis, it's likely that someone in that room knew the full 12-word recovery code?
Sooner or later, yes.
But
That's
by
that.
virtue of the verification, the mandatory verification process.
At some point there could have been back scrolling as well.
No,
So
but
it's not. Yeah.
Yeah, but I'm saying in order to carry out the verification process, that person who carried it out it's likely that they knew the full 12-word recovery code, because otherwise it's unlikely they would be able to carry out the verification procedure. Do you understand?
Yes, I do.
Thank you. But you don't even mention the verification step in your report, do you? And you've made, even after receiving,
I'm sorry, can you repeat?
Receiving Mr. Sabenic's,
Sorry. Can you start again? You've put to the witness that this is not mentioned. What you've just discussed with him is not mentioned in his report. And then do you want to follow up with a question? Take it nice and slowly. This is transmission around the world.
Sorry. And you would accept that in trying to ascertain how these Bitcoin was stolen, this would be an important point to take into account.
Yes, it would be.
But you didn't.
I considered back scrolling as being an important consideration, and one that I thought was the most likely initially.
Did you actually read the Trezor manual or consider the relevant software when you actually wrote your report?
Yes, I did. Right, I have read it before. I did not read through the entire thing again.
Now, I'd suggest that that's unlikely, given that you actually missed out this very important step in the setup.
Oh, come on, Mr. I'm not going to allow that sort of question to this to this witness. He's given his evidence that previously he would have read the literature that goes with the wallet, if I can call it the wallet manual, and so he would have had that in mind. Let's go on.
Now, going on to the PIN code,
yes.
You agree that it's a recommended but not a mandatory step?
Correct.
So it may have been that no PIN code was set up at all.
Yes, this was a mistake in the report. There was contradictory evidence, and I don't know if a PIN code was. We don't know if a PIN code was set or not, and if it was, by who.
Well, you say that the evidence is contradictory, but in fact, taking a step back, you list a number of witness statements that you say you considered in writing the report.
Yes.
And in fact, there's no evidence whatsoever in any of the witness statements that you say you read that in relation to a PIN code being set or not being set. There's no evidence whatsoever in relation to a PIN code, is there?
There was two statements. I'd have to look up the exact ones, but in one case it was said that in one case there was two different things that were contradictory. One said there was no PIN code set, and I believe the other one, it said it was set by I forget if it was the buyer or Mr. Thurner, but I recall it there being contradictory evidence. Well,
I haven't been able to find that. Maybe it's my mistake, but neither I nor any of our
these were in the these were in the amendments of the like in the claim submissions. If
you
I
mean in the
recall correctly.
Mr. Sibinek, do you mean in the pleading
Yes,
where
in
the
the,
case is
in the
formally set out?
yes, in the pleadings.
I see.
The defence, my lordship.
Well, we'll just look at that.
I will. I'll see if I can find myself.
Maybe I'll have a different amended defence. You can find the defence at 2-60.
Well, is Mr. Ahmed able to help? Is she aware of anything in the defence that is relevant here?
Okay, I have what I deem to be contradictory, and I can make reference to that.
If you could.
Yes. So in the claimant's amended reply to the amended defense of the first defendant, I'm looking at this. I'm not looking at this in the big hearing bundle, but I'll read out exactly what it says here. Further, in any event, the second defendant, on behalf of the first defendant, set the PIN code for the wallet and had access to it at all times. So in one case, it's saying Mr. Thurner set the PIN code. Now, in the first defendant's amended defense, in paragraph 43.3, it states Mr. Thurner was not asked to, nor did he set the PIN code for the Trezor wallet.
43.3 of
the first defendant's amended defense.
2-32 in the bundle.
2-32, thank you.
So I deem that to be contradictory, and it's I don't know.
But you'd accept that your client, Mr.
No, don't refer. He's not his client.
So okay. So now, so what we have established is that you missed out a key step in the process about the mnemonic, and we've also established that you've come here giving evidence today, not actually knowing which model of the Trezor wallet you're giving expert evidence on.
I'm sure I reviewed that in the past, but I don't think the Trezor model number is inherently important to remember off the top of my head, but I'm certain that I looked at it in the past.
Okay. Now let's assume.
Is there anything you want to add, Mr. Sibinek?
Yeah, it's not. It's the types of devices. Like, yes, there are two types of devices, but the significance of how they differ in the setup process is not fundamentally, there's not a massive difference. There's a difference in terms of the buttons, in terms of the types of cryptocurrency assets they can hold. But for security, for setup and security purposes, there's not a fundamental huge difference.
Now let's assume that one, the buyer hadn't tampered with the device in any way, and that two, the buyer was unable to record the entire mnemonic. Now, I don't think it's not disputed that TABARAK had possession of the physical device, the Trezor itself. Indeed, we know it was locked in TABARAK's safe.
Yes.
Now, in that scenario, it would follow, would it not, that TABARAK had actual control of the Bitcoin in the address if, one, either no PIN code was set, or two, if a PIN code was set and TABARAK knew the PIN code. Yeah.
That is correct. Yes.
Thank you. So you're saying that there's contradictory evidence that a PIN code was set. So
I'll say contradictory claims as opposed to evidence. Let's put
okay.
it that way.
Fair enough. Fair enough.
Thank you. So we don't know whether a PIN code was set, really. We don't know whether Mr. Thurner himself set and recorded a PIN code. Yeah.
Correct.
We don't even know whether Mr. Thurner was aware of the PIN code step and its optionality.
I do not know what Mr. Thurner did or didn't think. I can't read his mind.
No, the question is, we don't know exactly.
Oh.
And sitting here today, we don't know whether Mr. Thurner was aware that the buyer had set the PIN code. That's going to be a matter for the judge to decide. Yeah?
I suppose so.
Now, at 10.222,
Okay, yes.
now at paragraph 5.1,
yes,
you say that the buyer and not TABARAK, this is the last sentence, the buyer and not TABARAK controlled the wallet.
I'm referring to exclusive control. It is if theoretically no PIN code was set or TABARAK had access to the PIN, then there would have been a point in time when TABARAK could have theoretically have had access to the device, when it was in the safe, of course. But
Yes,
but I think we're in agreement that the buyer had control of the funds on the device.
I don't think there's any doubt that somehow the buyer obtained control of the Bitcoin in the address, but the point is here that you haven't actually set out in your report any of the options, any of the possibilities that might lead to TABARAK actually being able to control the Bitcoin in the wallet, do you?
Well, we actually discussed that quite a bit in the joint report, and we put that we talked about that as an option. We considered a lot of different breach vectors, including the possibility of collusion.
But hang on a sec. In the joint report, it's assumed that the buyer had the PIN code. So if TABARAK, even if TABARAK had the physical device, if it didn't have the PIN code, it couldn't have accessed the Bitcoin, could it?
It depends, depending on who set the PIN code. So if the person who set the PIN code was Mr. Thurner, you know, he could have, you know, passed that on to someone with TABARAK. But yeah.
But you accept in the joint expert memo, the assumption is that the buyer set the PIN code.
I think that's what we had initially stated, because we had missed one of the claims in that regard.
Now, moving on to the next topic, you make a number of allegations about the knowledge that HUOBI OTC, so that's the first claimant, ought to have had. So to pick just a few, at 5.3, paragraph 5.3, so it's the same page.
Yes.
You say that the seller isn't, you basically say that the seller's an OTC exchange and it would be expected to have adequate security protocols for the safety of transactions.
Yes.
Yep. Now, implicit in that is an assumption that HUOBI OTC was an exchange and that its business model and experience was in doing OTC transactions involving cold wallets. Correct?
Sorry, can you repeat that?
Implicit in your contention that HUOBI OTC would be expected to have adequate security protocols for the safety of the type of transaction that we're talking about involving a cold wallet. Implicit in that is an assumption that this was HUOBI OTC's day-to-day business, namely using cold wallets for OTC transactions.
It didn't necessarily mean cold wallets, but HUOBI OTC, to my knowledge, their primary businesses or a good portion of their business was OTC transactions. I think that would be fair to say.
But you do understand that OTC is a very wide term, and that all OTC means is that it's an off-exchange transaction that's basically a private transaction between two parties.
Yeah, it is a private transaction between that doesn't occur on an exchange, a typical exchange interface.
Right. And now you say that you read the witness statement of Mr. Al-Ali, his first witness statement, yes?
I did. I believe so, yes.
And had you done so and considered that witness evidence properly, you would have noted that HUOBI OTC's business model was to first be paid directly for the crypto, and only if payment had been received, to transfer any Bitcoin. Do you remember that evidence?
I read a lot of evidence, and I can't say I recall that specifically. But
so let's assume that it says that.
Yes.
You would agree that that scenario does not require necessarily that a cold wallet, well, it doesn't require at all that a cold wallet is used, because HUOBI OTC is receiving the money first before it transfers the Bitcoin.
That depends on how the transaction is being set up, whether HUOBI OTC is acting as a buyer or seller, or
Okay, so
maybe
so this is a sale of Bitcoin. It's very simple. HUOBI OTC's business model. It's paid by the buyer, and it then transfers the Bitcoin. So what happens is the money's paid into HUOBI's account by the buyer, or maybe by a credit card transaction. Very simple. Money comes in, it's logged, Bitcoin goes out. You do not need a cold wallet for that, do you?
You don't, but it also doesn't make a lot of sense to do what is described in many cases, because if all the funds are going to HUOBI, then HUOBI OTC, then the other party is trusting that that person is going to, that entity is going to pay them out in return. So usually
exactly, but that was the standard business model. That was how this was done.
I don't know if that was their business model or not.
I'm so sorry to interrupt you. You're being asked to assume that was the business model. So, okay, and it'll be for me to decide whether indeed it was the business model and all the factual questions that hedge around it. But please make that assumption and then give your evidence on the basis of that assumption. I want to put it again, Mr.
So assuming that the standard business model of HUOBI OTC was to be, first of all, paid directly for Bitcoin before it transferred any Bitcoin to a buyer, would you agree that this business model would not require cold wallets to be used?
Agreed.
So, given that you haven't considered what HUOBI OTC's standard business model is, you are not actually able to substantiate why HUOBI OTC would be expected to have knowledge of security surrounding the setup of a Trezor, a cold wallet like a Trezor. And you haven't been able, you're unable to substantiate also why it should have security protocols in place for cold wallet OTC transactions.
I can tell you as a general as a general rule, firms that engage in OTC trading have knowledge of these types of security practices, and it is the chief priority, as Mr. Saxena also as he indicated, it is a chief priority in these types of transactions, understanding how how there could potentially be a compromise, just because the stakes involved are so high, and that inherently requires all parties involved to really have an understanding, both the buyer and the seller in this regard.
So, but basically you haven't taken into account, you've wholly failed to take into account the possibility that HUOBI OTC didn't have the experience or knowledge in OTC transactions involving cold wallets. Did you?
I can't imagine an OTC trading firm that doesn't have that type of knowledge. So it
Well,
just never crossed my mind.
So you agree you didn't take into account that possibility even?
Well, his evidence is that from his experience in general in respect of those who trade OTC, he would expect both sides to be aware of the importance of matters of security to ensure that there's no risk, or risk is absolutely minimum. as to something going wrong and Bitcoin going up without being paid for. Now,
No,
you're entitled in your submissions to me to contend that that assumption may not be applicable here on the evidence, and it'll be for me to review the evidence. But I don't think you can take this any further with Mr. Sibinek.
My point being, however, that you didn't actually consider whether HUOBI looked to TABARAK to provide advice on the process for a safe transaction. That was something that you just didn't consider in your report.
I can't know the inner workings of the business model of HUOBI of OTC and the nature of all the types of transactions that they conduct.
And then, for example, if we go to 10.224,
okay.
you simply state that HUOBI OTC was responsible for security issues.
This is because parties that engage in cryptocurrency transactions, there's a certain level of responsibility simply because Bitcoin is a self-custodial asset. It's not like funds in a bank account at all. You really have to take a precaution when both engaging in transactions, but also even just holding funds, because as I mentioned in an analogy, it very much is like walking down the street with a briefcase loaded with cash. You'd want to just exercise reasonable diligence if carrying that amount of money.
So the point being is that you have not taken into account in your report an alternative scenario when it was actually TABARAK that was responsible for devising the process.
I'm not in.
Question, Ms. Chu.
I'm sorry, did someone else?
Sorry, Ms. Ahmed, would you allow me to continue?
Well, wait a moment, Ms. Ahmed. What was the?
My objection was that that's a legal question, isn't it? Not one that this expert can give an opinion on.
No,
I don't think. Wait a minute, Monsieur. No, I don't think so. Put the question again, Miss Stewart, and let's see how we go.
Mr. Sibinek, you failed to take into account in your report an alternative scenario whereby it was not HUOBI OTC that was responsible for security issues, but it was TABARAK that was responsible for security issues.
So there's a couple different things with security that I will say about here. There's what we'll call liability for who was liable for security in this transaction, which is very much a legal matter, which I will stay clear of. But then there's diligence and responsibility, just with regards to transacting in general, and just being diligent when conducting transactions and critical thinking, and taking, which is a bit different than the legal liability aspect, I guess I would say.
The point of the matter is that you failed to take into account at all the possibility that a company might go, any company might go to a regulated bank, for example, and say, we don't know how to use cold wallets. We don't know how to set up this transaction. Can you help us?
If a company theoretically did that, I'd question their competence for having access to 300 Bitcoin to begin with, because it would be negligent to give someone with, you know, that lack of knowledge access to the Bitcoin.
Right. If we can go to 5.26.
Yes.
Is that a page reference or a paragraph reference?
Sorry, that was a paragraph reference. It's
Okay. What page is it?
10.7.
10.7.
10.227.
Thank you very much.
Sorry, I'm sorry for interjecting, but my transcript seems to have stopped working. I don't know if that's the case for everybody else as well.
Has something gone wrong with the provision of the transcript? What do other people say?
This is the court reporter, so it seems to be scrolling my end. Perhaps a refresh might help.
Right, okay, thank you.
Okay, thank you very much.
Our
Indeed.
transcript is fine, my lord.
Good, good.
Yeah, mine seems fine.
Delighted to hear it. Give me the page again. I lost memory of it because of the transcript problem. It's
10.227.
10.6.7.
10.227.
I'm sorry, I'm getting deaf. 10.227. Okay, on we go.
Mr. Sebenik, as I interpret your evidence, in support of a contention that HUOBI OTC ought to have had knowledge of security of cold wallets, you rely on HUOBI's knowledge of security of cold wallets.
Are you saying I rely on HUOBI Global's knowledge of cold
HUOBI
wallets?
Global, yeah.
No, I don't think so. There's a relationship between the two entities. I'm not, you know, specifying exactly what that relationship is, but I wouldn't say it relies on that. Even if the HUOBI OTC were not affiliated with a major exchange, they should still have that knowledge.
So you're now saying you don't rely, just to clarify, you're not relying on the knowledge of HUOBI Global, and whatever knowledge HUOBI Global may or may not have provided to HUOBI OTC.
I'm not saying that that HUOBI Global provided that knowledge. No, is that what you're asking?
Well, that's certainly how I interpreted your evidence. You seem to rely at 5.26, 5.27. You talk about, I can say, reasonable belief that HUOBI Global does have people on staff that are knowledgeable, which would suggest to me that you somehow find this relevant.
Yeah, okay, I'll say how it's relevant. Obviously, they share the same, we'll call it brand. I don't know if you probably know better than I do if HUOBI MENA is an affiliate or a subsidiary of HUOBI Global, or what the legal structure is, but there is a relationship there, and I guess HUOBI. Go ahead.
Okay.
Go ahead.
But you don't actually provide any evidence in support of HUOBI Global even doing cold wallet OTC transactions, do you?
I never said HUOBI Global does cold wallet OTC transactions. No.
Okay, well,
They have cold wallets for sure. So they're competent with regards to security necessarily, otherwise they would have been hacked many times.
Sorry, are you saying that HUOBI Global does do OTC transactions via cold wallets?
I don't know, but I don't have any reason to believe that they do with that entity specifically.
But nor are you able to say there's no evidence to support a contention that HUOBI Global does do OTC transactions using cold wallets, correct?
Well, HUOBI OTC has.
No, I'm talking about HUOBI Global here, not HUOBI OTC.
I'm sorry.
Yes.
Yes. So, you know, HUOBI Global. It's my understanding that, you know, there would be some sort of relationship, and they have.
Right, my question is this: you do not have any evidence in support of HUOBI Global doing cold wallet OTC transactions.
No, I never
Thank
suggested
you.
that.
Well, let's get on.
Now, at 10.223, paragraph 5.5.
Yes.
My understanding, and correct me if I'm wrong, that you're in effect contending that HUOBI OTC blindly trusted what it was told by TABARAK regarding the safety of the Bitcoin transaction.
I wouldn't say blindly or completely blindly, but they didn't exercise due diligence themselves. Certainly not to the extent that should have been expected.
So nowhere in your report do you consider the assurances that HUOBI alleges TABARAK made on the 3rd of February in response to concerns raised by HUOBI OTC? You don't consider those concerns raised in the assurance?
I definitely considered those. There was concerns raised at various points by different parties. So they brought that forward, but they didn't. The HUOBI OTC proceeded with the transaction anyways. But yeah, they did bring up some points for sure, which is why I'm not saying they blindly, completely blindly trusted, but it's important to exercise a certain amount of due diligence.
But you've accepted that they didn't blindly trust. Thank you. Now, it would be fair to say that at no stage in your report do you consider whether a scenario whereby if TABARAK's responsibility had been to advise upon and implement a process for a safe transaction, whether one, that process was safe, and two, whether the assurances it's alleged TABARAK gave were in fact reasonable. You don't consider that alternative scenario, do you?
That is a pretty long sentence. Can you break that down?
Okay, sure. Consider this alternative scenario, and this might be something the judge finds, that if that it was TABARAK's responsibility to advise on and implement a process for a safe Bitcoin transaction. So that's an alternative scenario.
I'm sorry, I think you might have cut out. If Tabarak was tasked to advise and implement us on a safe process, what do you say after that part?
So if it was Tabarak's responsibility to advise upon and implement a process for a safe transaction, such that the Bitcoin couldn't be paid away before, couldn't be transferred before the buyer had paid for them, right?
Yes, okay, if that scenario, yes, then continue.
So you haven't considered in that scenario whether the process that was actually affected was safe.
Okay, well, I'll tell you right now, if in that scenario was case, I would say no, the process was not safe.
And you would also, I would assume, agree that if assurances were given by Tabarak to the effect that it was safe, then those assurances were not reasonable.
They wouldn't be reasonable because it wouldn't be safe.
Yes. Next question, come on.
Okay, 10222. Now, are you there, Mr. Sabanek?
Yes, I am.
Okay. 5.3. Now, in this paragraph, you consider AML and other regulatory requirements. Would you agree that, and I mean, maybe it's missed out of your CV, but as far as I can see, you're not a lawyer and you don't have training in compliance matters?
I'm certainly not a lawyer. I deal with compliance matters fairly often as an investigator.
And what do you understand by the meaning of the word compliance?
Well, there's a lot to unpack, but adhering to regulatory, adhering to regulations in specific jurisdictions, practices with regards to preventing or mitigating money laundering. There are some of the aspects of compliance for sure.
Okay, would you accept that this falls out of the scope of what you're permitted to provide expert evidence on?
What do you mean by permitted to provide?
The experts were permitted to provide to give expert evidence in a narrow, which did not, I would suggest, include regulatory matters such as AML.
I never opined on Dubai compliance laws and regulatory procedures in particular here. So I don't think that was. I just don't see the issue.
Right. Well, at paragraphs 5.37 to 5.39 of your report, and that starts at 10-229.
And sorry, 5.33.
Sorry,
to where?
So it's 5.37. There's a whole section titled Compliance Track Report of HUOBI, which goes on for 1, 2, 3. It's nearly 4 pages altogether.
Yep.
And in that section, you make numerous allegations and criticisms of HUOBI Global and HUOBI Global's KYC process.
Including the KYC process, yes.
And it would be fair to say, would it not, that the purpose of this very long section is to seek to persuade the court that HUOBI OTC failed to mitigate its losses, or to put that in non-legal terms, that HUOBI OTC didn't take reasonable steps to minimize its losses.
HUOBI OTC didn't take reasonable steps, yes, but also HUOBI Global, which is some sort of entity affiliated with HUOBI OTC, didn't do anything, or it seems to not have taken adequate steps either.
Now, you've read TABARAK's re-amended defence filed on the 9th of November.
Yes.
And there's just a short allegation in there on this, what I call the mitigation point, which says, further or in the alternative, the first claimant has failed to mitigate its alleged losses.
Mm-hmm.
Now, you would agree that there are no facts provided in that re-amended defence in support of that allegation?
I don't. I'd have to review that to be sure, but I do not recall there being specifics, anything along the lines of what I've said here.
Yeah. And in particular, there's no mention of HUOBI Global's obligation to mitigate losses. In fact, there's no mention of HUOBI Global at all in that re-amended defence.
Okay, I have to review to make sure there's no mention of HUOBI Global, but if that's what you're saying, okay.
And nowhere in your many, many pages on this theme, in this section, do you set out on what basis HUOBI OTC, a separate legal entity to HUOBI Global, could force HUOBI Global to do anything.
Well, they have a close relationship, and I do talk about that.
I think Mr. Sibenik.
Sorry, Mr. Sibenik, we lost you.
Oh,
a few moments ago.
Mr. Saxena, I think Shatnu Saxena was employed or working for both HUOBI MENA and HUOBI Global at the time, and I did mention that in the report. But also, given that these entities share the same underlying name, HUOBI, I would tend to assume that they have some way of internally communicating, and that they share some relationship in terms of a legal structure. Although I wouldn't know what that is exactly.
Okay, so you're not able to actually substantiate that point. But it's actually even worse than that, isn't it? Because your report doesn't actually mention that HUOBI OTC did in fact contact HUOBI Global to report the theft. And that is actually a widely known fact in these proceedings. Are you aware of that?
I was not aware of that, but if they did, I don't think appropriate action was taken by HUOBI Global, as is evidenced here.
And HUOBI Global isn't actually, as I said before, a party to these proceedings. So,
well, that's a question of law. The duty to mitigate is on the individual claimant. It may be that duty would involve seeking to elicit assistance from its associated company, and that's a matter of facts which can be explored and which are directly within the province of the judge rather than the expert witness, in my view. The expert might have something to say about what HUOBI Global might have been able to do in response to a request for assistance. But if HUOBI Global took a decision and not to implement any particular measures, then that is not something that is to the discredit of the claimant, it seems to me. So I think we can move on, and I'll read this parts of the report with that analysis in mind. Okay.
Thank you. I'm grateful for that indication. So in summary, Mr. Sebenik, you have missed out some key technical points in your report, not least about the verification.
Well, look, we've had all that. We're going over all ground.
And
There's no need for you to start summarising those matters which you've cross-examined in on. They're
Right.
on the transcript, and I've heard them.
Thank you. With that in mind, Mr. Sebenik, that's my cross-examination.
Well, thank you very much, Ms. Stewart. Now, who's going to be cross-examining on behalf of? Is it Mr. Matu or?
Yes, my lord.
Yes. Well, it's your turn now.
Thank you, my lord. Mr. Sebenik, in the joint memorandum, it is stated that a common misconception about Bitcoin is that Bitcoin wallets contain Bitcoin, correct?
That is correct.
In fact, in the joint memorandum, the experts agreed that the wallets only contain keys, correct?
They control key. Yes. The wallets do contain private keys. Yes.
So you agreed that the coins are not physically in the wallet.
Correct. Physical Bitcoin don't exist.
So the wallet is just allocated a Bitcoin address where the coins are recorded on the blockchain and can be accessed, correct?
Can you repeat that again?
So the wallet is just allocated a Bitcoin address where the coins are recorded on the blockchain and can be accessed, correct?
Addresses, but yes, otherwise correct.
You agree that the keys in the wallet are just signatures for transactions to allow them to take place, correct?
Yes.
And the address is just a destination for the transaction, correct?
The address is a public, it's a public identifier.
In the joint memorandum, it was stated that there are 4 possible breach vectors, correct?
Can you hear me?
Now we can hear you, sorry.
Okay, yes, that is correct.
And all of them are considered unlikely except for the tampered tracer wallet theory and seed phrase scrolling theory, correct?
That is correct.
And this seed phrase scrolling theory essentially provides that the buyer could have scrolled back to the previous 6 phrases noted by TABARAK, correct?
Yes.
Now, it's important for us to understand that each side, i.e. the claimant had 6 words of the password, and the buyer had the 6 words of the password. Claimant asked Mr. Turner and Ms. Zaviolova to record them, and the buyer had 6. Now, the probability of any of the 3 words, for the sake of confirmation at the end, being from either set of the 6 is not 50%. Isn't that right? It will be around 9%.
I'm sorry. Can you repeat that?
the probability of 3 words being from either exclusively of 6 word set of the buyer or the claimant 6 set is less than 50%, correct?
It depends which 3 words you're referring to, I guess.
So for the verification process at the end.
Yes, yes.
So when you have to randomly give 3 words to confirm,
Yes.
which could be from either the first 6 set or or from the mixture of the 2 sets, correct? Or exclusively from the second set. So the probability of all 3 words belonging to a particular set is less than 50%.
Yes, yes, it is.
It's not 50%, correct? It's less than 50%.
Yes, it is under 50.
Yeah. And they could have had either a camera, they being the buyer, or memorize the other 6 words, correct?
Correct. Those are our chief or most likely theories, I think.
But there's no evidence of this, right?
There's no hard evidence.
You know that in order to scroll through, the buyer would have to be careful not to appear that they're writing down more than 6 words, correct?
Correct.
And this is because scrolling between seed words happens one by one, correct?
Correct.
And so it would be quite apparent if someone was clicking the scroll button a number of times or taking longer than normal, correct?
Depends on how well they conceal it, because it's hard to tell when you're on the other side.
In the joint memorandum, you note 4 key flaws in the security protocols and procedures. And they include, amongst them, agreeing to use the claimant agreeing to use the Trezor wallet provided by the buyer, correct?
Yes.
The claimant agreeing to split the mnemonic phrase in the 6 sets of 2, correct?
Correct.
The claimant allowing the buyers and the claimant allowing the transfer of 300 bitcoins to the Trezor wallet prior to the funds having been received in TABARAK's bank account, correct?
Yes.
So you and the experts agreed that these 3 major flaws were the subject of an agreement between the claimant and the buyer, correct?
I think an agreement, you get into legal aspects of whether or not there was. So yeah, I just want to avoid opining.
That they agreed to proceed. I mean.
Yes. They agreed to proceed. Yes.
And then the final flaw is the seller's agreement with the buyer. Sorry, I've scratched that. You all then provide an example how an OTC transaction should have been done in the joint memorandum, correct?
Yes, I believe we provided 2 different scenarios. Yes.
And then you suggest that a OTC transaction should have proceeded as follows: the third party providing its own Trezor wallet, correct?
Yes.
And the buyer wiring funds to the third party bank account before the coins are transferred to the buyer, correct?
Yes.
And the third party provides the BTC address to the seller, the details of which are disclosed to all parties, correct?
Yes.
And then the seller sends the BTC to the Trezor device of the third party, correct?
Yes.
And then the BTC are verified and the third party sends the wire transfer to the seller.
Yes.
And then finally, the third party sends the Bitcoins to the Bitcoin address provided by the buyer. And that concludes the transaction, correct?
Yes.
And you agree that this should have been done in this scenario, for it to be security proof, correct?
It's not entirely security proof. There's still trust, involved with the third party, but assuming that that is a trusted third party, and assuming that all the parties are willing to fully trust that third party, then that would be fairly safe. Although we did present another option whereby whereby the third party would not need to receive the Bitcoin at all, and that would be just as good.
Could I take you to 8421?
Sorry, 8421 of the.
It's the bundle 8 in the electronic
Yes,
bundle.
Okay, I'm just looking for that right now. 8421.
Are you there?
I'll be there in 1 sec. 8, 4, 30. Okay, there. So I'm here. Yep.
So this is an third deal structure, the so-called third deal structure agreed by the parties prior to the transaction.
Yes.
Do you agree that this seems to conform to the procedure you outlined in the joint memorandum as being a way the parties should have conducted this OTC transaction?
Okay, let me review this. Okay. Well, there are other processes that are not elaborated here, but I don't see any inherent issue with these processes, provided there are other security processes in place on top of this.
Do you agree that the nature of an OTC transaction versus an exchange transaction is that OTC transaction as a process is done directly between the buyer and the seller, correct?
It's an agreement between a buyer and a seller. There can be an additional party involved, but at a base level, it is an agreement between a buyer and a seller.
So you would agree that in an OTC transaction, the buyer and the seller will fix the price of the transaction?
There needs to be some sort of way to agree upon a price at some point, for that to be fixed in order for the trade to occur. Yes.
You agree that from the evidence provided by the first claimant that it agreed to use the buyer's Trezor wallet in the transaction, correct?
I'm sorry, can you repeat that?
Do you agree that the first claimant agreed to use the buyer's Trezor wallet for the transaction?
Yes.
One of HUOBI's fact witnesses has testified in this trial that the ownership of the wallet would have transitioned from the buyer to TABARAK by virtue of the fact TABARAK setting up the wallet. Do you agree or disagree with that conclusion?
I'm sorry, can you repeat that once more? Sorry.
So one of the fact witnesses, Mr. Saxena, has testified in this trial that the ownership of the wallet, which belonged to the buyer, transitioned to TABARAK by virtue of the fact TABARAK setting up the wallet. Do you agree?
Wait a moment. We've got to be careful with the word ownership.
Yes, that's a
There
very
was the witness talking about custody, which is a different concept from ownership.
TABARAK never set up the wallet. It was not the wallet was not provided by TABARAK, and TABARAK never set it up in full. So I'm just not sure how you're considering that to be TABARAK's wallet, I guess is my.
If I ask this question, rephrase the question, you would not consider this wallet to be TABARAK's wallet, would you?
No.
So you then state that TABARAK never had exclusive control of the bitcoins, correct?
I said they did not have exclusive control of the Bitcoin.
This is because you agree that TABARAK never had control of the complete seed phrase, 12 words, correct?
That is correct.
And also because
well, I should say I should also add it was because they didn't have that, but also someone else did. So or appears to have. So that's why I say it's unless these types of wallets, it's very much about control. So there can be multiple parties who control a wallet if it is compromised, and in that case, well, whoever gets the money out first, gets it. That's how it.
And also, TABARAK never had exclusive control of the bitcoins because the funds of the buyer were never transferred to TABARAK, correct?
Correct.
And also because the bitcoins were transferred to the buyer's wallet. Isn't that right? So correct. TABARAK didn't have control because of that as well, correct?
Well, TABARAK could have had control. I said they didn't have exclusive control, but they could have had control if there was no pin set, or if if there was a pin set, if they had obtained the pin. And we had talked about the way that could happen because the TABARAK had the physical wallet in the safe.
In paragraph 5.2 of your expert report, you comment on the third deal structure at 10.222.
Okay. Just a second. 10.222.
Are you there?
Yes, I am now.
So you did review this deal structure, correct?
Yes, I did.
And in your experience and expertise, was this structure reasonable?
It was, if there were additions to that, it could have been reasonable, but I didn't see in any inherent issues with the things that had been established in this deal structure. But so you could say there would have been additional requirements on top of that, but nothing in there would have caused serious alarm for concern.
And in comparison to what happened, the deal structure on the 3rd of February, this structure was much more, you would agree, reasonable than that, right?
Oh, for sure. What happened on the 3rd of February was not close to this third deal structure.
And you comment that the third deal structure was not followed for several reasons, namely that TABARAK's wallet was not used, and therefore the first claimant transferred the 300 bitcoins to buyer's wallet, correct?
Yes.
And further, in your report, you state that it is standard procedure for the buyer and seller of the OTC transaction to agree on protocols and procedures to take place, correct?
Yes.
And you would agree that in this transaction that took place on 3rd of February 2020, there was no agreement on protocols or procedures that will underpin this transaction, correct?
Correct.
When you look at the parties to an OTC transaction, you agree that you would look at the sophistication and experience of the parties involved.
You're being a bit vague by that. Can you elaborate?
When you look at in a given OTC transaction, you agree that sophistication and experience of the parties involved does matter, correct?
In what regard?
In regard to how they agree to transaction terms, in terms of security, in terms of setting up the transaction.
Well, it's important. I wouldn't say sophistication is a necessary requirement, but knowledge and security, particularly with regards to security, is important, but it isn't inherently necessary to be sophisticated.
Do you agree that the first claimant, HUOBI OTC DMCC, was a highly sophisticated cryptocurrency company?
Again, sophisticated is a vague word, and I don't know all the things of how they are sophisticated or not sophisticated. My analysis is related to this incident in particular, and I can say they were not. Let's say they did not practice adequate security.
But would you say, as a company,
protocols.
HUOBI OTC DMCC should have had understanding of how a OTC cryptocurrency transaction should take place?
Absolutely.
Because they were in the business of this cryptocurrency transactions, correct?
Yes.
So it would be reasonable to expect the first claimant would have adequate security protocol, not just for safety, but also to ensure that the transaction is compliant with AML and other regulatory requirements, correct?
Yes.
Can I take you to 2597, please? Sorry, 9247. Sorry, I beg your pardon.
9247.
9247. Mr. Sidney, are you there?
1 sec. 9247. Okay, 9247. I'm here.
Okay. This is a WhatsApp exchange between the first claimants, Mr. Davar and Mr. Al-Ali and Mr. Saxena. At 11, okay. On 11th of February 2020, at 3:53 a.m., Mr. Davar is forwarding this message from HUOBI Global. As you can see, he says, "Hi all, for the tracking of this transaction." So this is after the transaction of 3rd of February, after the theft of 300 Bitcoins. He states that this time starting with the cold wallet address provided by a colleague from the Middle East. So you would agree that HUOBI Global and apparently HUOBI OTC DMCC had an understanding of what a cold wallet is from this message.
Let me see here. I don't see, starting with the cold wallet address provided by the colleague. I wouldn't necessarily say they knew what a cold wallet was strictly from this message. No.
But you would think that they at least have understanding of what a cold wallet is.
Well, they should. Whether or not they did is another issue.
And this is from, as you can see, at 3:54 a.m. Mr. Davar says it's from security team. So you would agree that they had a security team which was assisting them in their business, correct?
I don't know if it was a security team, but yeah, I did not see this before. There's obviously a
Mr.
lot of
Matthew,
documentation.
I'm a bit concerned about this. Here we have an expert witness who gives us the benefit of his expertise about how the transaction was dealt with on the 3rd of February. You're asking him now to construe and draw inferences from what is said by Mr. Tabark. I don't think you can. Wait a moment. He's given evidence that he would expect HUOBI Global to have security protocols and be aware of important security issues. And in his view, this is challenged by Ms. Stewart in cross-examination. In his view, HUOBI MENA, someone who trades OTC, would also be expected to be aware of the need for caution and to bear in mind security issues and the like. And I think that's it so far as what this witness can say as to what's to be expected.
Yeah, I did not read. I did not see this in the documentation before. There was obviously a lot of documentation in this case, but yes, that's.
Thank you, my lord. I'll move on.
Yeah.
So because of these security risk and regulatory considerations, you would agree that it sometimes takes time for parties to an OTC transaction to agree on a procedure, correct?
Yes.
So if the value of the BTC Bitcoin to be traded, the sourcing of the coins to be sold, and or the procedure of the transaction were changed at the last minute, the parties would be seen as negligent, correct?
I'm sorry, can you repeat that once more?
So if in a given transaction, the value of the Bitcoins to be traded, the sourcing of the Bitcoins to be sold, and or the procedure of the transaction were changed at the last minute of the transaction, this would be seen as somewhat negligent, correct?
Well, I don't think don't use the word negligent.
I don't think negligent is an appropriate word for that.
You could put it in terms of whether alarm should have been
alarming. Let's put it alarming. Yes, my lord.
Yes, it should have caused for alarm, but there are certainly OTC cases where parties meet and then there's an issue with regards to what they understood the practices to be, and then then maybe they abandon the deal. So it should have caused alarm.
You would agree that besides comments made in the claimant's pleadings, you have not seen any evidence of any assurances provided by TABARAK, correct?
Well, again, frankly, Mr. Martin, I'm afraid this is entirely a matter for me. This witness can't be expected to have absorbed all the many documents that are in play in this case to reach that conclusion, and it's not his role to either.
I'll move on, my lord.
Yes, please.
Even if the third party had the requisite knowledge and experience in facilitating Bitcoin or cryptocurrency transaction, you state that first claimant would still be obliged to consider security-related red flags, correct?
Yes.
So in order for third party let me rephrase this. As you note in your report and in the joint memorandum, all procedures were proposed and agreed by the first claimant, correct?
Yes.
Including the use of the buyer's trezor wallet,
Yes.
Well, sorry, that may be the impression of this witness, but it's for me to decide exactly what happened on the 3rd of February and what positions were being taken by the relevant people and the like. You can put a hypothetical question to this witness based on a possible finding that I might make, but you can't ask him to confirm what is essentially a matter of fact, which is for me.
Thank you for that indication, my lord. Would you disagree with the first? Do you disagree with the first claimant's expert that the order of transferring bitcoins before funds is an irrelevant consideration?
Well, I'm sorry. Can you repeat that once more?
So, do you disagree with the claimant's expert that the order of transferring bitcoins before funds reaching Tabarak's bank account is an irrelevant consideration?
I would disagree with that.
You refer to two statements made by Mr. Saxena in his witness statement, that he was not a technical specialist in crypto storage and transfers and therefore relied on Tabarak to make sure the transaction was secure. And he only discovered after the transaction on 3rd February that a user can transfer bitcoins out of a wallet without having any physical control over the wallet. And you call this absurd, correct?
Yes.
And this is absurd because given HUOBI MENA's advertised experience in OTC transactions, correct?
Among other reasons, yes.
And that all the first claimant's representatives on the transaction date, Mr. Al-Ali, Mr. Nahak, and Mr. Saxena were all senior representatives of HUOBI MENA, correct?
Yes.
And of course, as you mentioned, at HUOBI Global's 24-hour trading volume of USD 15.7 billion, correct?
At the time that I took that, yes, but it does vary considerably.
Even if we take Mr. Saxena's comments as true, you state that the fact that HUOBI MENA did not have anyone competent present at the transaction was per se alarming should have been alarming on the part of HUOBI MENA, correct?
Yes.
In your CV and in the introduction to your report, you state that you're the lead case manager at Cypherblade, a blockchain forensics and cybercrime investigation firm, correct?
Yes.
And that you consistently work with police, law enforcement, and regulatory agencies involving hacking, theft, and different types of frauds and scams, correct?
Correct.
And you're recognized as one of the few experts in blockchain forensics and cryptocurrency cybercrime investigations, right?
Correct.
And you state that in a Bitcoin transaction, you're able to track and assess where the Bitcoins have flowed and discern control or ownership of a given wallet or address, correct?
Correct.
And one of the tools you use to track such blockchain transaction is chain analysis reactor, correct?
Correct.
So you have significant experience working with this software, correct?
Yes, I use it daily.
You actually have a certification for this software, correct?
2.
2, that's even better. Now in paragraph 5.40 of your report, which is at 10:30.
Okay.
And you provide a very helpful diagram on 10:231 of where the Bitcoins were transferred after the theft of the Bitcoins on 3rd February 2020. Do you see that?
Yes.
First, you note that 300 Bitcoins were sent to the buyer's treasury at 9:10 UTC, correct?
Yes.
And then 299.90 Bitcoins were sent from Trezor to the thief's Bitcoin address 1JB at 11:07 BTC at 11:07 UTC, correct?
Yes.
Then the thief split the BTC at 14:23 UTC into two other wallets that were all part of the same 1JB address cluster, correct?
Correct.
And then minutes later, the 1JB wallet sends 136 Bitcoins to another address cluster 14B4, correct?
Yes.
Which you say is the cluster that's most likely controlled by the same individual that controls 1JB cluster, correct?
So someone involved in the theft, and I said it could reasonably be controlled by the same entity, but I cannot say that for sure.
You would agree this is this would be a reasonable inference because due to the size of the transfer, correct?
Yes. So there's good reason to believe that whoever the person would be involved in it in the matter, whether or not it's the exact same person that controlled the previous wallet is a different it could be different, but I would agree that they're involved.
And you would agree that this is a clear attempt to obfuscate the source of funds?
There were obfuscation techniques in particular. It doesn't necessarily mean this transaction was an obfuscation one in particular, but using multiple intermediary wallets in general is one of many obfuscation techniques.
And you would agree that it would have been difficult to set up a new transaction so close to the time of the original theft, correct?
Yeah, like it would have been difficult to liquidate via via like another OTC so quickly, because I believe the transaction happened just a few hours later. So that's why I do believe the address cluster is likely controlled by someone who's already involved in the incident, as opposed to maybe another OTC trading firm that is innocent and had no involvement in the matter.
Fifth, at 15:51 UTC on 4th of February 2020, the 14B4 cluster sends 3 transactions totaling 35.001 Bitcoins to HUOBI deposit address 1BY, correct?
Yes.
So this is the part of the transaction where one could state that 35 Bitcoins flowed back into HUOBI Global's control or jurisdiction, correct?
Yes, once it was transferred to HUOBI Global, they would have had control over it. They would have had dominion and control, yes.
So sixth, we see 5.5 Bitcoins being sent to an OTC service in China known as D Group or another HUOBI deposit address 1NW, correct?
They eventually make their way to another HUOBI deposit address, but as you add more intermediaries, there becomes an increased risk that the funds could have been passed off to another entity. But yeah, eventually they do make their way to that HUOBI deposit address as well.
So there's a possibility, according to your analysis, that 40.5 Bitcoins flowed back into the control of the HUOBI Global, correct?
Yes, and if you were to keep following the blockchain further, there's more, but follow these funds. Yep.
So in your conclusion on the tracing of the transaction, you state that the bitcoins in the 1PY address may not belong to the thief himself, but it may either belong to an OTC trading service or an individual facilitating OTC trades. Is that correct?
Okay, well, I'll explain this a little bit. So the way a deposit address for an exchange works, and I'll take 1PY as the example here, that would be allocated to a specific HUOBI account. That would to a corresponding HUOBI customer. HUOBI controls the funds at that address. Once funds are received at that address, those assets become under the control of HUOBI. HUOBI then adds a balance to the corresponding user account. I was suggesting that the corresponding HUOBI account was probably not probably did not belong to the buyer, but more likely belonged to someone that they transacted with, and that entity that they transacted with was more likely to have used an exchange deposit address of theirs to receive funds, as opposed to a personal or self-custodial wallet as a Trezor would be.
Thank you. And you go on in the report to show that 1PY address receives a very high proportion of illicit funds, including most notably from Bitcoin mixing, darknet materials, and multiple attributed stolen funds, correct?
Yes.
And you state that if the funds stolen from HUOBI, OTC, DMCC were incorporated in the exposure statistics of this address, it would indicate that at least 41.91% of the funds received at this address were either illicit or highly questionable, correct?
Correct.
So in your experience, was the tracing of this transaction a rather straightforward exercise?
It was fairly easy. Yes.
And if someone with the chain analysis software were to attempt the analysis you produced, do you think that they could have found similar results in a relatively short amount of time?
Only if they were appropriately trained and experienced in that. If they weren't, then they probably would not have found it, or at least not been able to demonstrate the flow of funds nearly as clear as I have.
Would you be surprised or alarmed to know that would you be surprised and alarmed if no one at HUOBI, OTC, DMCC knew about the existence and use of chain analysis?
If no one knew about the existence of it, I'd be very surprised. It's very common compliance software to have, although not the only compliance tool. There's other equivalents, but I'm sure some people there are familiar with it.
So you would agree that HUOBI, OTC, DMCC, or HUOBI Global would have some kind of software for tracing Bitcoins in-house, correct? Would expect.
I would expect them to have something. How good it is another question, and how much they utilize it is also another question on top of that.
And you also state that HUOBI MENA should have made sure that HUOBI Global was aware of the incident as soon as it happened, correct?
Yes, or yes.
And the reason for this is that the speed with which these thieves are able to move Bitcoin through different addresses requires one to be appreciative of the speed to trace them, correct?
Yes.
And you would agree that time is of essence in tracking these thefts, essentially, correct?
Usually, not always. In some cases, they can take longer to move, but usually it's you do want to get on it fairly quickly, get wallets attributed in various compliance software as having stolen funds, so that if an exchange were to receive those stolen funds, their systems would detect that, and they could take appropriate action accordingly in accordance with whatever compliance policy they have.
So would you, based on your experience, agree that an hour, 2 hours, few days could potentially, at what point would a tracing of Bitcoins and recovering them be jeopardized?
Sorry, what do you mean by that?
Meaning that so if one waits few hours, for example, after theft of Bitcoins, would that jeopardize the investigation or movement of tracing of the coins?
Not necessarily. Like this blockchain data is permanent now. I've done this in investigation and well into 2021, and if I were to do it again independently next year, the result is going to be the same. So waiting longer doesn't change the underlying data, but it could make matters more problematic from a recoveries perspective, for sure.
But it could jeopardize the recovery of the Bitcoins, wouldn't it?
Yes, if you waited longer, because if you wait longer to investigate or to mark certain wallets, then it gives additional time for those funds to be laundered, and then once they are laundered, there's no potential to freeze or intercept them, I guess you would say. But you would still have data related to the investigation, such as that, all the funds went to this HUOBI deposit address, for example.
Could I take you to 8508, please?
Okay, 8508.
I hesitate to interject. We've been going now for over 2 hours. I'm just
yes
about the transcribers. I don't know if Mr. Matu's got a long way to go. Or...
yes,
I
well,
would need
that's a
another
good
15
point
minutes at the most, I would say.
How many minutes?
15 minutes, my lord.
Well, let's have a word with the transcriber.
Yes, my lord, I'm here.
We've been going for 2 hours, and if you would like a break now, much more than waiting for another 15 minutes, you're very entitled to have a break. So can you give me some indication of what you require in terms of break?
I would like a break, sir, but I'm very conscious that the witness is in the middle of the night, so I don't want to.
Oh, that's okay. I'm a night owl.
Okay.
He says he's a night owl.
Okay, if we could have a break at a convenient point, that would be very helpful. Thank you.
Well, can you? We'll keep Mr. Matu to his word, and after 15 minutes. I'm going to expect him to have finished his cross-examination, and we'll take a break. At this point, I forget now what the usual length of the break is. Is it 10, 15? It's not when we take the 30-minute break.
It's a 15-minute break, my lord.
Sorry, what would you say?
It will be a 15-minute break.
Oh, 15-minute break.
Yeah.
So can we do that, please? We'll go on for another 15 minutes, and then we'll take a 15-minute break. And I'm expecting Mr. Matu to have concluded within those 15 minutes. We'll take a break, and then there'll be re-examination. Thank you very much.
Thank you, my lord. So have you reviewed this, Mr. Sipnick? Have you reviewed this tracing report prepared by HUOBI Global regarding the tracing of the coins the transaction in question?
No, I reviewed a lot of documentation. I did not see this.
You would note in this report, the conclusion is that they state that part of the assets, 35 BTC, on this is the conclusion on 8508. You'll see there's a paragraph 1 under conclusion subheading.
Okay.
It says that part of the assets, about 35 Bitcoins in total, flowed into HUOBI. One user got involved who currently has about 37 Bitcoins in his or her account. The account has been frozen temporarily, and the user is required to provide KYC and evidences about the origin of his assets. You see that?
Yes, I do.
So, given that HUOBI Global found that 35 Bitcoins actually flowed into users HUOBI's account, it should have been straightforward based on your experience for them to seize these and potentially liquidate these Bitcoins, correct?
I don't know about straightforward, but given that they would have had control of the Bitcoin, it would have been much less of an issue.
So if the first claimant took no action to seize these Bitcoins, you'd agree that it would be alarming for you that they had 35 Bitcoins in their exchange and they did nothing about it, correct?
Well, I think if there are cases whereby it would be alarming if they did nothing about it. Yes, whether or not they have the right to seize that is a different matter. But I think they did the right thing by asking for KYC and evidence of the origin of the assets in that regard.
Could I ask you this, Mr. Sivanek? For the Bitcoin to end up in this HUOBI global account, can we infer that some further payment would have had to have been made by HUOBI Global for these Bitcoins to become their property, in the sense that they are now nestling in this account?
So HUOBI Global did not, when HUOBI Global received the 35 Bitcoin here, they did not pay for them. What happened was they gave the corresponding account a balance of 35 BTC. The account owner could have then withdrawn or traded the assets. It would be, the 35 BTC would be considered a liability on their balance sheet.
So there was, in a sense, there was consideration moved, but in the sense it was moved in specie. There were 35 Bitcoin were to the credit of the transferor.
Yes, just because HUOBI Global received the funds did not mean they were they conducted a transaction to receive those funds. They accepted that and they credited the corresponding user account, and then it looks like they flagged and took some action here.
Based on your experience,
so sorry, Mr. Matthew, and I know I've said I'd hold you to 15 minutes. So looking at HUOBI MENA and HUOBI Global as an aggregated entity, if one's allowed to do that, even if these Bitcoin had been, if you like, returned by HUOBI Global to HUOBI MENA, HUOBI OTC, that aggregated entity would still have suffered a loss in the sense of the credit in Bitcoin to the transferor that led to the transfer into this HUOBI Global account. Is that right?
Well, if you assume that the HUOBI Global account owner is not the buyer, then and you assume that it was a transaction that the buyer made with the account owner, who again is someone other than the buyer, the account owner almost certainly sent other assets in consideration for the 35 BTC in exchange. But again, that's making those assumptions, because otherwise the account owner wouldn't have gotten them for free. And if those 35 BTC were frozen, that could, then the account owner could have been at a loss as a result of that. But you run into questions of whether or not they were justifiably frozen, such as if the account owner was negligent in their compliance or anti-money laundering procedures.
I see. Thank you. Yes, forgive me, Mr. Matthew. Go on.
Thank you, my lord. In your report, you go through several examples of what HUOBI MENA or HUOBI Global should have done as soon as they realize there had been a theft of the BTC. For example, you state that HUOBI Global should have made HUOBI Global aware without any delay, correct?
Yes.
And HUOBI Global should have contacted chain analysis, should have undertaken chain analysis or any other analysis to mark 1JB wallet, correct?
I wouldn't say there's. I would say I don't want to say specific companies in particular, but they should have undertaken efforts to mark certain wallets and track those funds.
And HUOBI MENA and HUOBI Global should have, or HUOBI Global should have assigned someone on their compliance team to track these funds on day-to-day basis, correct?
Or have someone who's competent in dealing with matters to track them. Yes.
And based on your experience, were these competently, according to what you've seen, competently handled after the transaction?
Well, they discovered some funds going back to HUOBI, and again, I was not aware of this, so that's I would look at that favorably. To what extent, how long it took them to detect this, what other actions they took, but yeah, they did identify this, which is good, and I believe it happened February 11th, which is still I think a week after the transfer, which is maybe that's on the longer side, but they did identify. So
would such freezing of accounts as we have seen in this report or seizure of funds be quite commonplace for compliance purposes for such a large international Bitcoin exchange like HUOBI?
It is. I don't know how you define common, but indications of suspicious activity.
Sorry, Mr. Sibnick, I couldn't hear what you said. Can you repeat that?
I don't know how you define common, but it does happen frequently when there is suspicious activity involved until further due diligence can be conducted.
So based on your understanding of a similar exchange, they would have expertise in handling such situations, correct?
For large exchanges, yes, for sure.
And HUOBI Global should have conducted enhanced due diligence on the identified users and accounts that they identified, correct?
Yes, I would. When you say HUOBI, you're referring to HUOBI Global, right?
Yes, HUOBI Global. Yes.
Yeah, and the question is, how those accounts were were identified. HUOBI Global, I would say, isn't, was not legally the victim here, right? They're maybe one of their responsibilities should be to avoid facilitating money laundering, just as another exchange, Binance might be, but I don't know if it's their HUOBI Global's responsibility in particular to track, but someone with HUOBI MENA, or if they designated someone at HUOBI Global to track, that would have been.
But you would agree that HUOBI Global was cooperating with HUOBI MENA and HUOBI OTC DMCC because they produced this report for them, correct?
Yeah, I would say there was some communication between them. Yes, for sure.
And HUOBI Global would have offboarded the account as well, correct?
That depends on the findings from the investigation and due diligence, really.
So of all these steps that HUOBI MENA, HUOBI Global did not undertake, for example, taking any legal action to recover these 35 Bitcoins, have you seen any evidence of any steps that they've taken to recover these 35 Bitcoins?
Well, I'm not privy to the personal findings, and I guess I could review this a bit more, but in terms of what interactions they had internally, it's harder for me to say that, I guess. It's I don't really know.
You give some examples in your report of how HUOBI Global as a company has deficient KYC procedures to identify fraud, correct?
They have had that, yes, for sure.
And these KYC procedures do not comply with industry standards, according to you, correct?
Now, where's this going? Just tell me what the relevance of this is, Mr. Matthews.
These questions are aimed at explaining experts' analysis on the KYC and due diligence procedure that HUOBI would undertake for its customers, to onboard its customers. And it's in the report of Mr. Sibning.
Was this something that this expert was instructed to opine on?
Yes, my lord. I think because that's why it's in his report.
Well, it doesn't necessarily follow.
Your Lordship, as I understand it, this is intended to go to mitigation, which hasn't even been pleaded by D2. So
I think it's an inherent point that we have addressed.
There are no such things as inherent points in this context, Mr. Matthews. It's an absolutely standard requirement in respect of mitigation that it's pleaded and particulars are given of the steps that should have been taken but which weren't. I'm not sure you can take this much further.
Okay, Malak, I'll move on. I just have a few more questions and then I'll be
Well,
done.
yes. Can you really get the horse to gallop a bit now, please?
Yes, Malak. In the final section of your report, you comment on the value of 300 Bitcoins lost, correct?
Correct.
The starting point of your analysis is that 300 Bitcoins is worth 300 Bitcoins, correct?
Yes.
But then you look to the intent of the parties and state that clearly the seller intended to receive USD 2,865,873.57, correct?
Yes.
But this would actually be less than the account opening fee, since it was expected to be deducted from the proceeds of the sale of the BTC, correct?
Yes, I think so. Yes.
And is this analysis even more accurate, considering that this is an OTC transaction where the procedure and price are specifically set by the buyer and seller of the transaction?
I think the point what I was making with regards to the price was that, or I guess the value was that the first claimant wanted something to happen, and the reason why these proceedings are happening is because they didn't get what they wanted. So that's why I saw the US dollar value that I stipulated as being the most relevant value. And they proceeded with the transaction in such a way that they even sent the Bitcoin to the applicable Trezor wallet in order to proceed with the transaction. That's why I see that US dollar figure as being the relevant figure for the purposes of loss calculation.
And you state that it would not be relevant to consider the value of 300 Bitcoins at the time of expert report or at the conclusion of the trial, correct?
Well, isn't all this a matter for me? I have to decide what the appropriate measure of damages are, and I don't think I'm assisted by this evidence.
In that case, my lord, I apologize for that, and I don't have any further questions for the expert. That concludes our.
Thank you very much, Mr. Matthew. Now, Mr. Severnick, we're going to have a 15-minute adjournment, and you'll be familiar from the other cases where you've been an expert witness that witnesses must not talk to anybody about the case, about their evidence, anything about the case to anybody until your evidence is complete, and it won't be completed until you've been re-examined by Mr. Ahmed. So please, during this 15-minute period, it's unlikely it's very late out there, isn't it, in British Columbia? Yes. There may not be anybody around to talk to about the case, but even if there is, please don't do so, and we'll see you again in 15 minutes' time, which means that we shall resume at 20 minutes to the hour. Thank you very much, everybody. Well, I think our 15 minutes have been completed. And so, Ms. Stewart, would you please proceed with any re-examination you wish to undertake?
Your Lordship, it's my re-examination, and you'll be pleased to know I don't have any questions to in re-examination.
I'm terribly sorry to have made that misidentification of who was asking the questions in re-examination. It's just that Miss Stewart looked as if she wanted to ask some questions that prompted that. Good. Well then, Mr. Severnick, that is the conclusion of your evidence, and I want on behalf of the court to thank you very much for making yourself available at a very late hour that most of us would find extremely inconvenient. You've been kind enough to say you're something of a night person, but even so, I think you're just being generous to you all. And I want to say how much we appreciate that you have given your evidence at the time and in the circumstances that have prevailed. So thank you, and you are released.
Okay, thank you.
Thank you, Mr. Severnick. Thank you, Your Lordship.
Well now, last factual witness, Mr. Turner. You're calling him Mr. Matthew?
Your Lordship, there was some agreement between the parties that we were going to hear all the experts today.
Oh, okay.
And we still have Mr. Aziz Malik's evidence to complete because Mr. Matthew was...
I'm not doing very well today, am I? I've forgotten that we have Mr. Malik to complete. Well, I think there's Mr. Matthew, you don't have much more with Mr. Malik, do you? Why don't we get Mr. Malik done and get him out of the way?
Your
Yes,
Lordship, there's one point which is Mr. McDougall, who is expecting to go next as the expert witness. He's also 12 hours behind. So he's also working through the night, but very kindly allowed D1's expert to go first because they insisted on that. So,
okay. that's, I think, a persuasive point. I had been under the impression that we were going to interpose Mr. Sibernick and then carry on with the factual evidence, because usually expert evidence comes only after all the factual evidence has been heard, so that the witnesses can be cross-examined by reference to what's emerged during the factual investigation. But if Mr. McDougall's been lined up, then we will proceed with Mr. McDougall and the other experts. So now, who's expert? Mr. McDougall is your expert, Ms. Stewart. So
Yes.
Let's go on with him. Now, all I want you to do to begin with is to have him identify himself and give him his address. Then I will swear him, and then you can take him through the usual formula. All right?
Mr.
Go on.
Could you give the court your full name and your professional address?
Sure, it's Joshua Randolph McDougall, and I'm in Toronto, Ontario, in Canada.
Well, I should say good night, Mr. McDougall. What time is it in Toronto?
It's currently 5:45.
5:45 in the afternoon.
AM.
AM, sir.
AM. Well, thank you very much for making yourself available. Now, I'm going to administer an oath, either a religious oath or a secular, invite you to affirm in a secular way your evidence. So I'm going to ask you, in effect, a question, and at the end of which I'd like you to respond either yes or no. I'm hoping it'll be yes. First of all, which sort of oath would you like to take, a religious oath or the secular affirmation?
Secular, Your Honor.
Thank you. Now, do you honestly, sincerely declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth, and the opinions that you will give are the opinions that are honestly held by yourself?
I do, Your Honor.
Thank you very much, Mr. McDougall.
Mr. McDougall, could you go to 10271, please?
Yes. Forgive me, the document is loading. All right, I do have this document in front of me.
Do you recognise this document?
I do. This is.
Sorry.
This is my amended report.
And at page 10295, hopefully there won't be a delay with loading.
$10,295. I do have that loaded now.
Is this your signature?
That is my signature.
And do the opinions you've expressed in this report represent your true and complete professional opinion on the matter to which they refer?
They do.
Can I ask you to go to 10-1?
Okay. I am currently looking at the expert joint memoranda.
Great. And do you, subject to what you've said in the first report I've taken you to, are the opinions expressed in this joint report, do they represent your true and complete and professional opinions on the matters to which they refer?
I have made 3 corrections to the report within my amended report. Outside of those corrections, the details within the expert report I agree with.
I'm grateful, thank you. Your Lordship, there's one thing that occurred to us, and if D1 and D2 jump up and down and object to this, they're understandable. We have actually got a photo of a Trezor wallet that may assist in just picturing what this is about.
We do object, Your Lordship. We haven't had an opportunity to see this. We haven't taken any instructions from our expert.
No, but perhaps if there's time after we've had all the other evidence in, I am quite curious to see what a Trezor wallet looks like, but it would only be to satisfy my judicial curiosity, and nothing could be made of what I happen to see. I mean, I've got a pretty good idea of what a Trezor wallet is, but I don't know what it looks like. So we won't do that, but we might at the end of all the evidence, if there's time, and it can be done very quickly, I might be interested in seeing it, but not now.
Or maybe if we could receive a copy of the set picture and then we can consider it, maybe that we won't have any objection.
No, I don't want to take up. We're really under pressure of time.
Your Honour, if your curiosity piques in the meantime, Mr. McDougall's expert report has a wiki and a footnote, and that has a picture of the Trezor wallet in that wiki.
Thank you for reminding me of that. That's very kind. Right. So can we move to this witness's cross-examination, beginning with Ms. Ahmed?
Yes. Thank you, Your Lordship. Mr. McDougall, I'm acting on behalf of the first defendant in this matter, and I'm going to ask you some questions about your report. I assume that you're satisfied that your report presents your true opinion and you don't want to change it.
That's correct.
And the reason why I ask is because you've said that you corrected 3 aspects of the joint memorandum, didn't you?
Correct.
And your first report was submitted on the 14th of November. That's correct, isn't it?
That sounds correct, yes.
And you then submitted 7 days later a further report making amendments to your first report, didn't you?
Correct.
And therefore it's in that context that I ask that, are you satisfied therefore that you don't want to make any further amendments or changes now to your second report?
Further to new evidence, I am satisfied with my report.
Now, you've also provided a declaration, and I don't need to take you to that, but I will if you want me to. But you've said in that declaration that you've exercised reasonable care and skill in order to be accurate. So I'm going to suggest to you, or rather put to you, that is it the case that you didn't exercise reasonable care and skill when you were putting together your opinion for your first report in the joint memorandum?
No, I don't agree with that. I think the ability to amend one's report is there for a reason, and in light of what was found, it required amending. In light of what, sorry? I didn't catch your answer. In light of review of the witness statements, it required amending.
So are you saying that you didn't review the witness statements when you prepared the joint memorandum or your first report?
No, of course not. I reviewed quite a number of documents in preparation for these reports.
Can I ask you to turn up your CV, please? It's at 1041. It was attached to your first report, and I'm working off your first report unless there are amendments that I need to take you to in your second report. Okay, that's fine. I'm familiar with both reports. I am looking at my CV now. Thank you. Thank you. I'm just observing the picture. I'm a little different looking now, but it is me, I promise. Just a bit. Right, okay. Slightly distracted by that. You've set out your qualifications there on the left-hand side. Do you see that there? Mm-hmm. And it's right, isn't it, that you don't have any legal qualifications, do you? Correct. And if we go through your relevant experience, you've given your background there, that you specialize in blockchain technology. And in the context of your relevant experience, and if we go through it, it's right, isn't it, that all of that relevant experience really deals with cryptocurrency, Bitcoin, blockchain type transactions, be it forensic analysis, investigation, tracing, due diligence, and so forth.
Let me just review this. No, there's experience in there beyond simply my blockchain-based experience, including forensic analysis, and I believe assistance in e-discovery matters. But what you don't have in there, do you? Any experience about escrow services, how they might be provided, what constitutes escrow services, do you? Because I don't see it there, Mr. Sorry, I'm just looking. One moment.
Well, Mr. McDougall, we can short circuit this. If you did have experience, then that would be in your CV under relevant experience, wouldn't it?
No, so there is a details here on CCSS assessments and CCSS readiness. And those were both with organizations that deal with escrow type services.
Because you co-authored the cryptocurrency security standard, which you refer to as CCSS, didn't you?
Correct. It is a mouthful.
And that was introduced in 2014, wasn't it?
I believe that was introduced in 2016. C4, the nonprofit organization that started it, was established in 2014.
Is somebody else there with you in the room, Mr. McDougall? Because I saw you look to the side of the screen before you answered the question.
Nope, I just kind of look off into my own thoughts. I am currently here alone.
Thank you. So you say it was introduced in 2016, and it's right, isn't it, that this is, you say that it's to complement existing standards like the ISO 2700I. Is that correct?
Correct.
And it doesn't replace them?
No, it does not replace them. It complements them.
It complements them. Now, in terms of the CCSS, you've just given an answer that it's in relation to escrow services, but it's more in relation to the security and safety of crypto wallets, isn't it?
Yes, the CCSS is designed for the safekeeping of digital assets, both helping, say, small organizations and individuals in helping them keep assets safe, as well as very large organizations in the digital currency space, such as, cryptocurrency exchanges and other financial services.
And just going into the next document, because it's easier to go to after your CV, that's 10-43, and that's the letter of instruction that was sent to you by CRS, wasn't it?
Document is loading up currently.
In particular,
yes,
I'm looking
that is that document.
Thank you. I'm looking at 10-45.
One moment. Okay, I do have that document in front of me now, and that page.
Paragraph 2.1, there's a reference there under that paragraph. The first paragraph, parties were given permission to rely on the report of an expert in the field of cryptocurrency transactions, including their transfer, storage, and value. And that makes reference to the amended case management order. And if we quickly go there, that's at page 10-143. And the particular page is 10-145. It's paragraph 11. Each party shall have permission to rely on the report of an expert in the field of cryptocurrency transactions, including their transfer, storage, and value.
Okay, yep, I do have that in front of me.
And so you accept, don't you, that it's your remit to provide an opinion on the transfer, storage, and value of BTC cryptocurrency transactions. That's correct, isn't it?
I would agree with that.
And that is because that is your area of expertise, and anything beyond that would not be within your area of expertise, would it?
I am an expert in the transfer, storage, and value of cryptocurrencies.
And it was those instructions and paragraph 11 of the case management order that informed your discussions at the joint memorandum or the joint meeting between the experts.
Correct.
Which culminated in the joint memorandum.
Correct.
And in fact, the corrections that you made to the joint memorandum, those were not matters that were discussed between the joint experts, or at the joint meeting rather, were they?
The verification phase was not discussed between the experts, but the process in which it was missing from was discussed with the experts. As for the first correction, that was regarding the PIN code. The PIN code was discussed between the experts, and the second correction made, sorry for going out of order here, but the second correction was simply a misspelling, or not misspelling, but a typo of the word purchase instead of purpose. So that was certainly, not intended by the joint meeting of the experts, but required verification, as there was confusion over whether or not a stage actually required purchase. When it did not, it was in reference to the purpose of something.
And let's go to your corrections. Now I'm turning to your second report. It's at 10-338. And do you have that there?
That page is loading. Thank you. I'm looking at correction 1.
Yes, and this is where you refer to no PIN. There's no evidence provided regarding a PIN number being set up on the Trezor wallet.
Mm-hmm.
I think it's incontrovertible, or there's no dispute that having a PIN would have probably made this transaction more secure.
It's a very difficult thing to judge. Which party is setting the PIN? What's the length of the PIN? Who is holding that PIN? If the question is whether or not, if the defendants had said it, would it have made it more secure? In this case, it doesn't seem like that would have been the case, because the buyers would have already had, theoretically, these 12 words. So setting a PIN afterwards would not have made things more secure. If the PIN had been set theoretically by the buyers, then that would have actually quite hindered the process, because then they wouldn't have been able to, kind of perform that role that they had involved themselves in. And obviously, if the sellers had set the PIN, then similarly, it would have been, assuming the 12 words weren't in the buyer's hands, also a more complex process that doesn't actually bring security. So I don't know if adding a PIN code in this, especially in this case, would have improved security at all. I think it would have been just an extra layer that didn't really accomplish adding to the security of it.
So I think if I summarise your evidence, and if I understand it correctly, what you're trying to say is that in the context of this transaction, setting a pin would have made no difference whatsoever.
So it could have made a difference in that, in this hypothetical situation, if Mr. Thurner or his assistant had set a PIN code, what assurance that would have given is that while the Trezor sat in the safe, no one with access to that safe, while those two people were out to lunch, would have been able to take the Trezor and issue a Bitcoin transaction with that device because they would have been stopped by the PIN. So
but you're
I guess in that one scenario, there would be a purpose to the PIN.
Yes, but your earlier response was, as I understood, that would only make a difference if the PIN was set before the wallet went to the buyer.
No, that's unrelated, because the buyer having access to the 12 words is unrelated to the security mechanisms on the Trezor. Similar to how the buyers having the 12 words meant they didn't need access to the safe. The buyers having the 12 words meant they didn't need access to the PIN code as well if it was set. They had these 12 words. These 12 words are the secret that allows them to spend the Bitcoin. The PIN code is simply a security mechanism that protects possession of the device from authorizing transactions, if that makes sense. Otherwise, I can try again.
So going back to my earlier question, in the context of this scenario, and not a hypothetical, in reality, what happened on the 3rd of February, the PIN code is irrelevant and wouldn't have made a difference in any event because the buyer had access to the seed words. That's correct, isn't it?
Yes. Yeah.
Thank you. Now, correction number 2, as you rightly said, is just rectifying a typo. It should have said purpose rather than purchase. Can we go to 10-340? And this is your 3rd correction that you've made to the joint memorandum. And you've accepted that this was not discussed during the joint meeting with the experts, was it?
Correct.
And you also say at the bottom here at paragraph 34 that we know it was performed by one of the parties. Now, are you just saying that by implication?
Well, we know that the verification step is required. So it was performed by one of the parties that had the Trezor in their hands and involvement in the process.
Can I move on to your opinions provided in your report? And as I said, I'm going to refer to your first report unless there is a correction that I want to ask you a question about or an amendment. It's 10-21, please.
Sure.
And you've given your
page is just.
Oh, I beg your pardon. Sorry.
No, you can start. The page is loading.
Thank you. Your first opinion is based on your background, training, education, and experience that the defendants provided escrow services to the claimants. Now, we've already explored with you that your CV is absent any reference to any background, training, or education that you may have had in what amounts to provision of escrow services. But dealing with your opinion there, if I can go back to paragraph 8, please, where you say, and that's at page 10-16, the opinions and conclusions expressed herein are based upon my understanding of the facts in this case, as well as information gained during the course of the assignment. Yes? Now, it's right But nowhere in your, and I just want to explore your understanding of the facts of the case and where you've got those from. There was no discussion, was there, at the joint meeting of experts about the defendants offering an escrow service, was there?
There was discussion, there was disagreement.
Because if we go to 10-2, that gives us the contents of what was presumably discussed at the joint meeting.
That page is currently loading.
We don't see any reference there about any discussion regarding escrow services, the provision thereof by the defendants.
Yeah, there was very clear disagreement. So it was not added to the joint memorandum in which we agreed upon.
And we've already been to your letter of instruction, and that's sparse in, or rather it doesn't mention, you agree with me that it doesn't mention anything about the provision of escrow services, does it?
There was in the, sorry, can you rephrase that? Or can you repeat that?
We've been to the letter of instruction and we can go there again. It's at page 10. It starts at 1043, 10-43.
But Ms. Ahmed, this letter of instruction proceeds from the wording of the permission for expert evidence that was contained in the case management order.
Yes.
And all three experts would have been subject to the same ambit of permission.
Yes.
And we have heard opinions from Mr. Sibinek about the role that was being played by your clients in the events of the 3rd of February, and the analysis of what occurred on the 3rd of February includes a close examination of what role your clients were actually playing. It's contended on the part of the claimants that they were performing a custodian / stakeholding role, escrow role. And at the moment, I don't see how this witness can be prevented from expressing views on that possibility.
And I appreciate your comment. I just wanted to explore with this witness where he gets his opinion from that the first defendant was in fact providing escrow service.
Well, that's fair enough. That's fair enough. But I don't think it can be said that any view that he gives as to a particular actual or hypothetical role played by by your clients is precluded from the breadth of the permission that was granted. That's all. So carry on.
No, I understand that. And what I was going to put to this witness was he had the claim form, he had the particulars of claim, and I want to understand and explore with Mr. McDougall, if I may, the basis upon which he says that that TABARAK was offering escrow services, and in what context?
Yes.
So Mr. McDougall, you've heard my statement to the learned judge. You had the claim form, you had the particulars of claim, and you had the reply. And nowhere in there does it say that TABARAK was in fact providing escrow services. So why do you say that?
So my experience within escrow services is on execution, is on how they're done properly. And my analysis of this situation is exactly from that same mindset. Seeing what took place and understanding that, what took place from a cryptocurrency perspective was that of an escrow service. At least from my experience being within and consulting within services that perform that role.
But it's right, isn't it? The reality of this situation, the transaction that occurred on the 3rd of February, is that the wallet was provided by the buyer. You accept that, don't you?
Correct. That's agreed upon.
Yes, and TABARAK didn't have full, complete, 100% custody of the wallet, did it?
I disagree with that.
Well, why do you disagree? Because you don't dispute the fact that the buyer had access to the wallet, do you? In fact, you say that in your report.
Correct.
So, the 2 bullet points, you refer to the fact that the buyer was permitted to supply the Trezor wallet device and the buyer should not have been included in the setup. So the buyer did, or rather the buyer did have access to the wallet, didn't it? Didn't it?
I agree. The buyer had access to the wallet. When I say that the defendants had access to the wallet, I mean they also had, the ability to create transactions. When I look at custody, I look at the ability to create transactions. So they were involved in the key system. Yes, it's fairly clear that the buyer had access to authorized transactions on the Bitcoin network, but I would also say that the defendants, in their possession of the Trezor, including in the safe, gave them access to create transactions as well.
Okay, Mr. McDougall, let's just explore that for a second and break it down. Let's go to even before it gets into the safe. You've accepted that the buyer provided the wallet and also agreed that the buyer had access to the wallet when he put in his seed words, or rather when he was accessing or trying to get the seed words. Yes?
Unintended access, but intended access, yes.
Well, putting aside intention, he did, didn't he? As a matter of fact, he did. He had the wallet in his hand and he was noting down the second 6 set of seed words, wasn't he?
Yes.
Right. And so therefore, it has to be right, doesn't it, that the TABARAK did not have full 100% custody of the wallet, did it?
I would say they were not sole custody of the wallet, but they had the ability to create transactions. So I would.
But what do you mean when you say they had the ability to create?
I think TABARAK had the intention of having sole custody of the wallet.
Right. Let's put aside intention and let's work out sort of what you believe to be the assumed facts. When you say they had the ability to create transactions, maybe I'm being obtuse, but I don't really understand what you're trying to say.
As in, possession of the Trezor wallet would allow them to send Bitcoins related or currently, assigned to that Trezor wallet.
Allow them being TABARAK?
Whoever has possession of that wallet. In this case, it was TABARAK.
So what you're saying is a general proposition that whoever has possession of the Trezor wallet allows them to deal with the Bitcoins.
Correct.
And so therefore, a logical conclusion ought to be that if TABARAK doesn't have 100% possession of the wallet, which it didn't, therefore it's right, isn't it, that it's not, the wallet isn't in the exclusive control, or the Bitcoin isn't in the exclusive control of TABARAK.
I don't believe they were holding the wallet physically together. The TABARAK did have sole possession in the form of storing it in that safe and leading up to that safe, if I understand correctly.
Yes, but I'm going to the steps before we get to the safe. Going through the steps, okay. Buyer turns up with his wallet, doesn't he?
I believe 2 wallets.
2 wallets. And so he gives one to Mr. Turner. Mr. Turner opens the wallet, and therefore it's been alleged that there is some assessment of whether or not this wallet has been tampered with. Mr. Turner then puts in the first, or rather, the first 6 words are generated, mnemonic words are generated, and he notes them down. You accept that up to that point?
I believe it was his assistant that noted the words down. Then the wallet is given to the buyer to note down the next
set of 6 mnemonic words. That's right, isn't it?
That's what's in the witness statements.
Yes. And therefore, and the wallet themselves don't contain the Bitcoin. The Bitcoin's on a chain, isn't it?
Correct. The wallets or the Trezor in this case contains a secret, and that secret is used to authorize the movement of Bitcoin.
Yes. So therefore, it's right, isn't it, that the Bitcoin or the accessibility to that Bitcoin isn't in the exclusive control of TABARAK, is it? Because the buyer has noted 6 of the mnemonic words required to access the wallet. To access.
Correct. If you want to use the term exclusive control, neither party, by which I mean the buyers or TABARAK, had exclusive control over it.
So even on your analysis, it's right, isn't it, that this is never a true escrow service, is it?
I go back to my statement that I believe the intention was to create a proper wallet that would store the crypto during the transaction until authorized to move to the buyer.
When you say proper wallet, what do you mean? There's an intention to create a proper, what's the difference?
Pardon me, a secure wallet only controlled by one party.
Right, so a secure wallet only controlled by one party, and which was not the case here, because you also say in your expert report, at paragraph 43, that, let me start by 42, despite defendants performing actions of an escrow, many serious mistakes were made, which directly led to the loss of the Bitcoin assets. A process proposed by the buyers significantly expanded the attack surface of the Bitcoin during the transaction. And so this was a process, wasn't it? That actually, well, the process that actually took place on the 3rd of February was a process that was proposed by the buyer. That's what you say in your report.
I base that off of the witness statements, I believe.
So therefore, intention doesn't even come into it, does it?
Well, this.
Sorry, can you repeat that one?
Oh, just wait a moment.
Sorry.
There are 2 considerations here. One is whether TABARAK assumed responsibility as an escrow agent or as a custodian. And the other question is, well, how did they, did the way they in fact conduct a transaction conform to what's to be expected from an escrow agent or a custodian? Now, my impression is, but Mr. McDougall, tell me if I've not got this right. You're the witness, not me. My impression is that you have inferred from the witness statements and so on that you saw that TABARAK was assuming the responsibility and role as an escrow agent or a custodian, and that in the way in which the transaction went, they departed from what they should have done in the performance of that role. Is that right?
I would agree with that.
Right. Now, so Ms. Ahmed is well entitled to ask you about the soundness of your conclusion that it was understood that TABARAK would perform the role of an escrow agent or as a custodian. But that leaves separately the possible finding, and I'm the finding of fact, that if I were to find that TABARAK in fact led the claimant to understand that they would be performing the role of an escrow agent or a custodian. Then we examine whether or not they perform that role properly. Do you understand? So Miss Ahmed is well entitled to ask you to challenge your apparent conclusion that TABARAK were expected to be and agreed to perform the role of a escrow agent or custodian when you look at the way they went about the transaction.
Thank you, Your Lordship. Just dealing with that last point then, and the summary. Now, on your opinion, in your opinion, you say that they were assuming the role of escrow agent and custodian. And it's right, isn't it, that if we take that opinion forward, then you would expect, wouldn't you, or in your opinion, in assuming that role, or anyone assuming that role, would be or would have knowledge and experience of handling a cold storage.
Cryptocurrencies can be a very complex beast at times. I would certainly, in my experience, businesses that take on that role are taking on risk, and thus they have to manage that risk themselves. And in fact, they don't want the other parties to manage that risk because leaving that to others becomes an issue. So in my experience, yes, I would expect those in that role to have an understanding because they are taking on that risk. For the buyers and sellers, it is a risk transference to this third party, so that way the deal is executed safely for both sides.
Yes.
And that risk is being taken on momentarily throughout the transaction by that third party. So I would expect that they know what they're doing, to be blunt. But again, this technology, and I think it's easy to appreciate the confusion around something that seems so simple and logical, such as only getting half of this secret and thinking that that is secure. I think there's certain levels of expertise and certain levels of understanding in this space.
So you'd agree with me that there is a certain level of expertise that's required to understand, and just dealing with the answer that you've given, understand that there may be a security risk by splitting the users of the wallet, so that one person has the first 6 words and the second person notes down the second 6.
I think although all 3 experts, and I think they agree with me based on the joint memorandum, agree that splitting the passphrase is a poor security strategy, to put it mildly. I'm not sure if that is necessarily common knowledge amongst all executives and cryptocurrency users in the space.
And so you'd expect, and what you said, it's not common knowledge, and therefore there requires a degree of professionalism with the knowledge and experience of handling a wallet of this nature and the security surrounding the wallet.
It does require a certain level of responsibility, yes.
Not just a certain level of responsibility, a certain level of expertise, doesn't it?
Yes.
And if we can go to paragraph 36, and I think it's your second, the supplemental statement. I beg your pardon. It's not that. Can we go to, I think it's an exhibit. It's your CCSS exhibit, the Cryptocurrency Security Standard. It's 10-184. And what we see there at the bottom of the second paragraph, and I think this concurs with your last response, as with any standard, knowledgeable and experienced security professionals are necessary when implementing any information system. And that would include, wouldn't it, this BTC transaction that took place on the 3rd of February?
Correct.
And you've also given evidence or your opinion within your expert report that Mr. Turner didn't apply any of these CCSS standards, did he?
What I mentioned is that on a number of cases, or a number of instances, he addresses different aspects of the standard, but does so in a poor manner.
And would that suggest to you, or rather it would suggest to you, wouldn't it, that in fact he has no idea about this cryptocurrency security standard, does he?
Quite likely, but I don't know whether or not he is or is not aware of the cryptocurrency security standard.
And therefore it's unlikely, isn't it, that he is the sort of professional that you talk about in the second paragraph of your CCSS to have the knowledge and experience to conduct this type of transaction.
Correct, but I don't think I suggest that he has the capability to do it so much as he did address the different things you would expect in a key system to, again, just show his involvement within the key system.
And if you turn to 10-17 of your report,
it's loading, one moment. 10-17?
yes, 10-17,
Great.
paragraph 13.
Great, thank you.
And the reason why they don't have the requisite knowledge or experience and cannot be properly described as a security professional in the way that you state in your CCSS is because TABARAK is only licensed to provide financial services. It can't be a security professional in these types of transactions, can it?
Oh, I don't think.
I'm sorry.
I'm sorry.
Sorry,
I don't think you can put that. Whether or not they, whatever their state of expertise and experience is entirely a matter for me. And of course, the focus shifts to the experience of Mr. Turner. And of course, it's not impossible for citizen A to agree to undertake the role of a escrow agent or custodian, even though he may be short of the necessary experience.
Can we go back to your CCSS, your standard, 10-184?
I just want to correct, you mentioned my standard. It is not a standard written entirely by me. I am one of the co-authors, but there are also many, many other contributors from around the industry. So I don't want it to come across that this is simply a document written by me. This is something that's been peer reviewed by many in the industry and is used extensively. Thank you.
No, I understand. And what that says is cryptocurrency security standard is set of requirements for all information systems that make use of cryptocurrencies, including exchanges. And I think at the start of your evidence, you did say that this you expect or rather this would apply to exchanges. Now, you are aware, and I'm sure you are, that HUOBI MENA is a cryptocurrency exchange, isn't it?
I believe it's an OTC dealer, not an exchange, but that's fine.
And this, what we're looking at here, is a set of standardized requirements. So you'd expect, wouldn't you, that HUOBI MENA to be familiar with these standards?
It would certainly be within their industry to be aware and implement such standards as well.
And given you the,
but I also,
sorry,
no worries.
No,
that's okay. I had a long pause. But again, I go back to my original statement of risk transference and you know, one of the reasons for using these types of services. Normally, going into those situations, you do not dictate the protocol that is in place because it is up to that third party to manage that process. So although I would hope that they would understand these protocols, that doesn't necessarily mean that they would be accustomed to enforcing their own protocol during meetups.
And given you co-authored these set of standards, did you ask at any point whether or not they were familiar or whether they applied to this standard?
I have not.
Can I ask you to turn to 10-222, please? This is Mr. Sibenek's report. I'm assuming that you have seen it.
Yep, I have reviewed it. Thank you.
And if we look at paragraph 5.3.
5.3.
And it's halfway in that paragraph where it starts, in this case, the seller is an OTC exchange and it would be expected that they would have adequate security protocols for not only the safety of the transactions, but also to ensure that the transactions are compliant with anti-money laundering and other regulatory requirements which would be applicable to the seller in this case. And it's right, isn't it, that you would agree with that statement, wouldn't you?
My expertise is not in AML compliance, and I wouldn't be able to really speak to what I would expect any of the parties to adhere to in that. As far as,
what about
go ahead.
The paragraph? The seller is an OTC exchange and would be expected that they would have adequate security protocols for safety of the transactions.
I honestly think an adequate safety protocol would be to have a third party in place to facilitate a proper transaction amongst the other two parties.
And can I then take you to paragraph 5.12, please? That's at 10-225.
That's just loading. Can you repeat the paragraph?
Yes, 5.12.
5.12, thank you. Okay, yep.
And Mr. Sibenek says, in his opinion, none of the parties involved in the setup of the Trezor wallet were competent in matters of security, except for perhaps the buyer. Would you agree with that statement?
Matters of security is a very loose term. I would have trouble necessarily completely agreeing with that. I think I believe the HUOBI OTC was represented by a number of executives. Were they understanding of the complete use of a Trezor? It does not appear that that was the case based on the events that took place. Are they, familiar with how to staff a department or how to work with custody providers? to maintain the safety of their assets. I can't speak to that as I did not necessarily read further information within the statements that would kind of indicate that.
And if we go to your second opinion, opinion 2, that's at 10-26.
Mm-hmm.
What you've said there, that based on your background, training, education and experience, an escrow service defines the protocol of the transaction. And in paragraph 41, you've given a general proposition to say customers of an escrow agent are not expected to be experts in defining protocols for the safe execution of transactions. Yes?
Yes, and again, that's based off my experience on the execution of escrow type services as an advisor and consultant.
Yes, so that's a general proposition. Now let's just take that general proposition into a more specific arena. And let's say the customer here that you're dealing with has certain characteristics. Let's say, for argument's sake, number 1, the first characteristic is that they are owners of a cryptocurrency exchange who have a JV agreement with, let's say, a global company who has a turnover of 1.3 million. So let's say that's the first trillion, rather. Okay. The second characteristic that I want you to assume, that this customer that we're talking about here also has experience and knowledge of establishing the modality of buying and selling Bitcoin. Third characteristic, that the customer has access to a team of safety experts who has the ability to advise them. And so in that context, would you still maintain, let's say that with the customer that I've given you, would you still maintain your opinion at 41? Would you expect?
I mean, I would. The expertise and the global depth of a team going into a situation in which they expect a neutral party to perform their actions as required. Again, we're talking about, you know, executives going into this meeting. Is it the security team that's in this meeting? I think there's just, you know, a lot of questions there that, although it's a very well laid out scenario, and I can say, you know, yes, you would expect them to disagree with what's taking place. I think I also, I think if you take a look at the fact that the 3 cryptocurrency experts got together, talked about the joint in the joint memorandum, and we missed a verification step, which was, you know, very, very important to detail. So I think it's, again, easy to say that with all the expertise, one can have, you know, instant foresight and understanding as to what to do with the situation. But I think these are complex situations in which certain things that an attacker can use, such as the buyer in this hypothetical case, can be a little bit of misdirection.
And what about if I add 2 extra layers to this customer that we're talking about here? Let's say the customer has read an article about flaws in the Trezor hardware. So can I ask you in that context to turn up 8-664?
It was 8-664?
Yes, that's the first page of the article. The attack requires 15 minutes of physical access to the device. And then if we go over the page at 8-666, in bold, do not allow anyone physical access to your Trezor wallet.
Okay.
So your assumed customer, as I've said, has access to a security team, can establish a modality of the transaction, has also referred or has reference to this article, and therefore understands the risk if the buyer has access to the wallet. In terms of paragraph 41, it's right, isn't it, that in this context, the customer that I've spoken about, with the characteristics that I've referred to, would be expected to be experts in defining protocols, wouldn't they?
Well, I'm sorry to intervene again, but the level of expertise and experience of the three representatives of the claimant who attended the meeting on the 3rd of February is a matter of fact to be decided by myself. Now, as to a different question, and that is, what would one be entitled to expect of individuals like the third defendants? The relevance of that may go to the way in which Mr. Turner conducted himself during the course of the meeting. But short of that, it seems to me the only real relevance of what one might have thought at first blush would be the expertise and experience of individuals like the three that appeared, would go to the issue of contributing negligence. And so, and I'm well alert to that issue in the case. So I think we've probably explored enough about the expectation as to knowledge and experience and access to protocols and the like, that one would, in the first instance, expect from these three individuals. But ultimately, it's a question of, well, what was their actual experience? And that is a matter for myself, save for some relevance going to the issue of contributing negligence. So I think we might, having heard me on that subject, we might move on to, you've got several other points I'm sure you want to raise with this witness.
Yes, and I appreciate your interjection, my lordship, but it was just simply the opinion that this expert has given, and he'd made a general proposition in his expert report, and I was simply exploring that with the specifics of the actual transaction itself. But I hear you, and I will move on. Now, can I then ask you to turn to paragraph 31?
Of my report, I assume?
Yes.
The amended or the
First one,
initial reports?
22.
Can you give us it again, please, the reference?
10-22, paragraph 31.
Thank you.
And now what you say there, the bank account provided by TABARAK to the buyer can be seen as analogous to the Trezor device used to control the Bitcoin during the transaction. And 2 points there, really. The first one is that there was no bank account provided by TABARAK to the buyer. So where did you get that from?
It was my understanding that they were monitoring a bank account for a deposit.
Right, but that's not the same as
Is that incorrect?
Well, that's not the same as the bank account provided by TABARAK to the buyer.
How would you phrase the account in question that was to receive the fiat currency?
Right, okay, I understand your point then. What you're saying is you're referring to the bank account details that were provided to the buyer to transfer the money rather than a bank account that the buyer, that TABARAK gave to the buyer, right? Okay.
Yes, I apologize if that wasn't clear.
And you say it's the bank account, what you're trying to say, as I understand, and correct me if I'm wrong, is that what you're saying is that a bank account is analogous to a Trezor device. But that's not a correct analogy, is it? There are differences between a Trezor device, like a Trezor wallet, and a bank account, aren't there?
Yes, of course there's differences. Yeah.
Yes. So you'd accept that that's not a true analogy then?
I think for the purpose of that paragraph, it was accurate.
But as a general proposition, it's not a true analogy, is it? Because Trezor devices are self-custodial, bank accounts are not. Trezor wallets, you can have complete access, bank accounts you can't.
Pardon me, a bank account is non-custodial?
Well, a bank account is administered by a bank, isn't it? A bank holds funds in custody on behalf of its client.
Okay, yeah.
And a Trezor wallet, it's self-custodial.
It can be, but I think this is an example of also which the Trezor would be used as a custodial service.
Right, but again, I'm going back to my point that it's not a true analogy, is it? Because again, a Trezor wallet, you can have complete access to a Trezor wallet with a mnemonic phrase, but that's not the case with a bank account, is it?
I agree that bank accounts don't have mnemonic phrases that back them up, but they are both basically account numbers that have funds associated with them and have control mechanisms in place. Who has access to those control mechanisms, how those control mechanisms are executed, I agree are slightly different, but the Trezor can allow one to execute on an account type system. It's very similar to how a bank account would. I'm certainly not saying that they're the exact same thing, but I think for the purpose of this analogy that there is enough similarities.
And if we go to your opinion 4, you predicated this opinion on what you say assumptions and assurances that you say Mr. Turner gave from paragraphs 46 right through to 53, yes?
Yes, these are assuming that those are correct. I'm not opining on that. Or assuming that they did occur, I'm not opining on that. But if they did occur, these are my opinions based on them.
And what you've said is whether or not that advice was reasonable. That's the advice that, or rather the opinion that you've given.
Correct.
What you've also said, and I'm paraphrasing, is that by including the buyer in the key system, there was significant compromise to the security of the wallet system.
Yep.
Now, in the context of the reasonableness of the advice, and that's an opinion you've given, coming back to the customer with the characteristics that I provided to you, and on the basis that I say TABARAK was an investment management firm, do you still say that the advice was, or rather that HUOBI MENA should have relied on that advice that you say is reasonable?
I've advised many different investment funds in the space that deal with cryptocurrencies and are able to do with that in a safe and secure manner. I don't think being in financial services does not preclude someone from being able to understand how to deal with cryptocurrencies.
But would you agree with me that HUOBI MENA, being the seller in this transaction, with the characteristics that we discussed and explored earlier, would have more expertise than TABARAK in conducting this transaction?
Based on these hypothetical questions being asked, it looks clear that they didn't have that expertise. They were looking to TABARAK for these answers. And they were, in a fairness, reasonable questions to ask and concern of the situation.
Thank you, Mr. McDougall. I don't have any further questions. Thank you.
Thank you very much, Ms. Ahmed. Yes, cross-examination on behalf of the second defendant. Oh, we're going to see another of the two-party team.
Yes, Your Honor, I'm back.
Yes, good. Well, on you go.
All right. Hi, Mr. McDougall. My name is Brian Kotick. I'm a counsel for the second defendant. I'm going to try to avoid any duplicate questions posed by Ms. Ahmed since we're addressing the same report. So I hopefully we'll get through this quickly. I first want to quickly approach your involvement in the joint memorandum and the possible breach vectors that came out that were agreed between the experts. Now, the most likely theory that you put forward was this seed phrase scrolling theory. Is that right?
Correct. That did appear to be the most likely.
And this essentially provides that the buyer could have scrolled back to the previous 6 phrases noted by TABARAK.
Oh, I apologize. My network connection cut out there for a moment.
So the seed phrase theory essentially provides that the buyer could have scrolled back to the previous 6 words in the phrase and therefore had access to all 12 words. Is that right?
That is the theory, yes.
And this theory doesn't really have any evidence that such scrolling occurred. Is that right? This is just the most likely.
So the verification step actually, with the inclusion of that phase, provides a little bit more evidence that there was possession of those different words, because they would have had to do that verification step directly after, and that step is likely would have asked for at least one of those words from the previous set. Similarly, that verification step, when incorrect, if the person is unable to provide the right word, actually brings you back to the process in which you see all 12 words again. That way you can verify that you have them.
Right. So in effect, this is actually a different theory. Is that right? It's not that the buyer scrolled. It's that a failed verification process has now brought him back to all 12 words, and therefore it's in effect a different theory.
I would accept that it was partially a different theory, but from a mechanic perspective, either they scroll back to the top or the system sends them back to the top. The end result is kind of the exact same in that situation. So I think there's kind of 2 different crossroads that end up in the exact same kind of methodology in which they get to see all 12 words.
I note your point there. Thank you. And in your amended report, let's talk about this verification process, because the verification process came from a wiki page from the Trezor user manual. Is that right?
Correct.
So you had access to this before you prepared your initial report and before you prepared the joint memorandum, but it was not included until you did your report.
Yeah.
Is that because you found out about the verification process afterwards when you were doing research, or?
Yeah, I thought the verification process was optional, and further research proved that that was not the case. It was a required step. So I had to amend based on that.
Okay, and so as you said, this verification phrase, if you put in the words incorrectly, you see first you're prompted to give 3 of 12 words, correct, that are picked at random.
I'm not exactly certain that it's 3, but it's either 3 or 4, but they are at random, yes. So it will say, give me word 1, give me word 5, 7, 8. Sorry.
And this can come from any of the 12 words, is that right?
Of course, yes.
And considering that Tabarak had noted down 6 of the words and the buyer had noted down 6 of the words, the chances of the buyer having, or luckily being able to enter in one of his 6 words of those chosen is quite small, is that right? On a mathematical probability?
Yeah, I wouldn't use the term quite small, but it's more likely that they include both sets.
Right. Now you state that you're able to then see if you get it incorrect or correct that you're able to see all 12 words, or the potentially able to see all 12 words?
Only incorrect. If you get it correct, the process is complete.
Okay, so if you get it incorrect, then you state that you see all 12 words at once. And I checked the wiki document that you noted, and I don't see any reference to this point of seeing all 12 words at once. So I was wondering where your source for that information was.
I must have misspoke, as you're displayed all 12 words, but you do have to scroll through those in order to see them. They're not all displayed on the screen at the exact same time, but they are all displayed in sequence to the user again.
So basically what you're saying is that you are repeating the seed phrase noting process.
Correct.
Okay, so it's not like they all appear in one image and you can write them down quickly.
It displays them, at first it displays 2. As you scroll through, I believe it displays upwards of 3 at a time.
Okay. Now, there was another breach vector that came out in your joint memorandum, and that was the tampered Trezor wallet theory. Now, although the experts agreed that the seed scrolling theory was the most likely because it was the simplest to explain, the tampered Trezor wallet theory was not necessarily ruled out. Is that correct?
Correct. None of the 4 options or possibilities were inherently ruled out. We're not in the room. We can't be, sure which one took place. But like the other 3, the tampered Trezor device is one of the possibilities, though unlikely.
Right, and that's because there was no evidence either way that the Trezor was tampered with, provided to you in the preparation for your memorandum.
I have not personally reviewed the physical device. It's my understanding that it's, I believe, still in police custody. But
have you reviewed a Trezor device for tampering before in your experience?
I have not.
Okay.
Not for tampering. Sorry, let me rephrase that. I have received a new device taken out of the package and plugged it in. I have not. I'm not an electrical engineer, so I have not done review of a device, I would say, at a forensic level. But I have done it as a consumer, if that's a fair differentiation.
But if you were to receive the Trezor wallet back from the police, you would not be able to do the analysis required to determine whether it was tampered or not.
I personally would not, but I have a wonderful team of people behind me in which we would be able to likely perform such analysis.
I guess we all need access to an expert team, don't we?
It helps.
So now I just want to go through your opinions one by one. And before I do that, I just want to, there's been, and I've had to go through this with a witness as well, there's been escrow or custodian thrown around between yourself and counsel. And from your opinions, it seems that you are stating clearly that TABARAK assumed the role as an escrow service and not solely as a custodian or a custodian?
I think that holding custody would have been, a portion of that service, but the act of reviewing, thank you, the act of reviewing, the funds coming in and then authorizing those funds to go out, theoretically, had this transaction gone through, that I see as actions of an escrow service that holds custody of the assets, but for the purpose of escrow.
Right. So there's conditions that are put on the custodial arrangement. If it were an escrow service, that would
If it were an escrow service, exactly.
Right. Okay. Now, in order for you to arrive at your conclusion that the defendants provided an escrow service, you basically talk about how being involved in the key system is a position of responsibility. And this responsibility provides services such as exchange and custody of Bitcoins, right?
Okay, yeah.
But when we talk about custody, your only reference about custody really is about TABARAK having a physical custody of the Trezor wallet. So I just want to be clear, is that the scope of your definition of the services undertaken for custody, is the physical custody of the Trezor wallet?
The physical custody of the Trezor wallet did inherently also mean custody of the Bitcoin asset, because having physical access to the Trezor device gave them network access to move those funds. So I do see that custody both as physical custody of the physical plastic device, but also custody of the Bitcoin asset through the private key or seed phrase that was embedded in that device at the time.
Right. So in order for the expectation of custody to be met, the seller would have expected that the device itself and the seed phrase be in possession of TABARAK.
Correct.
Okay. And then to go back to your analogy with the bank account, there was a bit of discussion on this bank account and how it was analogous to the Trezor wallet. And I see your point that it's basically to hold funds without giving access to anyone else. And that was the intention of TABARAK's bank account. Is that correct? Sorry, did you cut out?
No, I think his system is frozen.
Okay.
I apologize. I was having some bad connection issues. You're
Okay,
coming back. I apologize. If you could try again.
These things.
That's fine. I'm just talking about TABARAK's bank account and your analogy. Okay. And you say that basically the reason why it's analogous to a Trezor wallet is that it keeps the funds out of control of the buyer and the seller. Is that right?
Correct.
And you do agree, though, that the funds were never transferred to TABARAK's bank account, whether it was provided to the buyer or under monitoring of TABARAK, that no funds were actually received into the bank account.
That would be what the statements would say, yes. I would agree with that.
Right. So because no money was ever transferred into that bank account, then we can kind of remove that expectation of a custodial service from the equation. Is that right?
I believe there was an expectation by at least one of the parties that those funds would be deposited into that address. So I don't think we can remove that.
Okay. Now you go on, so in order to establish these escrow services, you discuss how TABARAK and Mr. Turner became involved, quote unquote involved. And I just want to kind of follow your logic here. You're saying that if there's enough involvement in the process, that leads to the creation of an assumption of responsibility.
Yeah, again, my experience comes from the execution of these types of systems. So what I see through reading these statements and the evidence before me is an involvement in that process, both as taking a piece of that key, as well as taking possession of that device and holding that device both physically in their hand, as well as within a safe within the business. So I see many different ways in which they were involved in that key process, which if they weren't providing any services whatsoever, they should not have been involved in any of those steps. Maybe at most the safe, but there was so much more than simply the safe at play here.
But you do not address how this involvement what pieces of this involvement are required to establish this escrow service that you claim, in your opinion, to have been created. So what I gather from your report and from what you just said is that if we look specifically at Mr. Turner's involvement in executing the transaction, he had a direct involvement in the key process. He made a specific decision to split the mnemonic phrase, even though that was agreed by the parties. Mr. Turner and his assistant were involved in commencement of the initialization process, and Mr. Turner provided a laptop. So is this the foundation on which you base your opinion that this was an escrow service for Mr. Turner on behalf of TABARAK?
Involvement in the key system, including the details you just mentioned, as well as being the monitor of both, or monitoring both the blockchain, the Bitcoin blockchain, I should say, as well as monitoring for deposits into the bank account. All of these together, for me, from an execution standpoint, look like the attempt at an escrow service, despite it being fairly unsuccessful.
You don't address the impact where if the buyer was involved in holding part of this mnemonic phrase, do you?
Well, the buyer wouldn't be their own escrow provider.
But do you think that it would lessen the expectation of an escrow service if there was someone other than the third party involved in these activities that you stated?
I think it lessens the effectiveness of it substantially. But if there was no escrow provider here and it was simply the buyer's own wallet, then TABARAK would not be involved in the setup, initialization, and safekeeping of that wallet within the safe system.
So you do not. Okay, so you are saying that as relates to the mnemonic phrase and sharing that with the buyer, something to which the seller consented, that would have an impact of some sort on the establishment of the escrow service.
I think it would have impact on the effectiveness of the escrow service.
Do you think it would defeat the purpose of having an escrow service at all?
Clearly it has, so it's difficult for me to say there are cases in which it shouldn't. If all parties were acting in good faith, then theoretically this escrow service with the buyer having half a key could have still been successful. And ultimately, we don't know. It could have been TABARAK sending the assets onwards, or it could have been the buyer then taking possession of this device from the safe. We don't really know how this could have ended. All of that is hypotheticals. So to say that it could have been effective, clearly it wasn't, which I think is the important thing in this situation.
So not necessarily the effect of the escrow service, but the purpose of establishing an escrow service. So setting up the escrow service. Would that be defeated if the buyer were included in the process?
theoretically, if the buyer had not copied the remaining 6 words, then you know, the system could have still worked. But allowing that to happen gave them, it kind of opened up the door to this attack taking place.
Okay. Now, just for the sake of completeness, I just want to note that you had 4 criteria here that you said Mr. Turner met for under the CCSS standards, including reviewing the packaging for signs of tampering. He demonstrated an understanding of the sensitivity of the data, and there was a physical storage of the Trezor, and he assured the buyer that the Bitcoins were received to the wallet. Is that correct? These met the CCSS standards?
They are examples of components of the CCSS. It's not that his actions met the requirements. Okay. My point within the paper was that the actions were examples of managing a key system, not necessarily that they were effective controls.
You said he met this control on several points.
There might have been one that he met. I apologize.
Okay.
Yeah, examining the package as an example would have been, you know, part of meeting that control. But splitting the key would not have met that specific control. Gotcha.
Now moving on to opinion 2 of 4, you state that an escrow service defines the protocol for the transaction. And the basis for this opinion, you have 2 sentences. You state that the escrow agent manages their risk by defining a protocol. And you actually stated earlier in your testimony today that it would not be in their interest to, or an escrow service would never allow other people to define the protocol because it would shift that risk and it would lessen their ability to manage that risk. Do you remember stating that?
I did state that.
Right. So if the escrow agent, assumably the allegedly escrow agent, did not define a protocol for the transaction, would you say, and I pose this to you again, that there was no de facto escrow arrangement?
I go back to what I've said previously, which is I have to look at what was done, because that's my expertise, is the execution of it. So what I see was the examples of a person or business taking control of a situation in a way that is an escrow agent, despite maybe not appreciating all the risks or appreciating the nuances of cryptography or key systems. The actions I see were that of an attempt at being a neutral third party to hold custody of assets until the agreed upon metrics were hit, and those assets were then moved on to their appropriate parties.
So let me pose a hypothetical scenario for you. 2 parties go into an OTC transaction and there's a neutral third party. The buyer proposes a wallet, the seller contests to the wallet or agrees to the use of that wallet. Then the buyer proposes setting up the wallet. The seller objects and says that the neutral third party should do it. The buyer proposes that the Bitcoin should be transferred first. The seller agrees, and the neutral party basically facilitates that transaction. Do you think in that moment where the proposals are coming from the parties themselves and the neutral third party is just facilitating that transaction, that an escrow arrangement would have arisen?
Are they taking custody of any of those assets?
Yes, but they're not defining the protocol.
But they're taking custody of the assets. I would say it's I guess I would change my opinion a little bit and say that an escrow service can, for business reasons, decide to allow that to take place and to allow their buyers and sellers to call the shots. but from a risk perspective and from an insurance perspective, in my experience, that would be a very dangerous proposition. Taking on that risk of custody without having the proper terms in place as to what that protocol is, and without having control of that system that you're taking custody in. I guess the question is, in this hypothetical situation, does the custody provider, or pardon me, does the escrow service take no control of the Bitcoin, or do they?
Yes, let's say the coins are transferred to the buyer's wallet, so they don't have custody.
And what about the US dollars or whatever currency? How is that transferred?
That can be transferred to the seller directly.
Then there's no escrow in place. No one is holding assets in this. There's not an escrow service.
Okay.
So there's been no risk taken on by that neutral third party. So why wouldn't they care who defines what protocol?
Right. Now, you state that your opinion 3 is that the defendants did not adhere to industry standards for an escrow service. And these industry standards, if I'm correct, relate to some regulations, regulatory breach of the duties of authorized firms. Is that correct? What industry standards are? Yeah, I can point you to the.
Oh, I mean, as I'm talking about, industry standards as far as the safekeeping of digital assets. So in this case, I'm talking about the CCSS as well as those other industry standards on security, such as ISO 27001 and the NIST framework.
Okay.
So I'm not mentioning specific regulatory and legal requirements in that. That's not my expertise.
But do these regulations bind authorized firms and companies, or do they regulate individuals?
Again, I'm not clear on. Maybe you can repeat that question a different way.
So this ISO regulation, that is basically the main regulation in place that your standards supplement. Those only regulate authorized firms within the meaning of the DFSA, or not, or in the example, the DIFC, the DFSA, but an authorized firm or company.
Yes, those would be organizational standards, not individual standards, if that's the question.
This would mainly affect TABARAK, is that correct? As a company?
Correct.
Okay. The final opinion that I have for you, or that you gave to us, is that assuming the advice was given by the defendants, it was unreasonable. Is that right?
Correct.
Now, I just want to go to your instructions that were provided to you, and this is at 1048, because you go through a list of statements that were taken by the claimant's list of issues. And you break them down in your report one by one and kind of respond to those statements. I just want to ask, these statements that were provided for you they were posed to you as advice. Is that correct? This was not your own independent determination that these statements must be classified as advice.
Correct. I'm simply going by the assumption that they were. It's not my place to opine on that.
Right. Okay. So if we go through a couple of these statements that were provided to you, we'll firstly look at 10-291, which is paragraph 61 of your amended witness statement.
I'm just loading that still. That was 10-291.
10291, and it's paragraph 60.
Thank you for
That
patience.
there was
Okay.
no reason to be concerned.
Mhm.
And this is basically one of the pieces of advice you were instructed to assume, is that correct?
Correct.
And then you write, if we assume this to be true, it is an unreasonable statement. Is that correct? You write, it is an unreasonable statement.
Sorry, I lost. I'm a page off. One moment.
Paragraph 60, it is my expert opinion that this is an unreasonable statement.
I actually say that this is a reasonable statement.
Paragraph 60?
Wait, 60. Sorry, pardon me. That was 61. My apologies.
Yeah, sorry.
Okay.
Now, I think you can appreciate if we were to use just common sense and also your depth of expertise, that such a vague statement, whether it's true or not, since this has just been instructed to be assumed, is not something that could reasonably be relied on by a large cryptocurrency exchange to change any opinions that it's had regarding the safety and security of Bitcoin transactions. I can rephrase that if I dragged on too long.
Well, are you referring to HUOBI Global or OTC as well?
OTC, but I mean, I'm basically looking at the phrasing of the statement posed to you, which that is, there's no reason to be concerned. Do you think that in your expertise, this is something specific enough to be advice that would cause a party to change its position on the basis of this statement?
I think that's a very, very difficult question to answer. I mean, I can see how it would be construed as a simple pleasantry in a way, but also it is, you know, a statement of assurance that things are fine, especially when they have, you know, theoretical concerns over that process.
And if we look to the second paragraph as well, just in the same line, that the transfer would be, quote, safe, quote.
Mm-hmm.
And then it's added, meaning that there will be no appreciable risk. And I think, again, you can appreciate, using your expertise, that such a vague statement that a transfer would be safe could never be stated, because no transaction is ever 100% safe.
And in this paragraph, I say this is actually a reasonable thing to say. With an escrow service that's confident in their abilities, they would, you know, certainly have the controls in place to assure their clients that is good, that it will go through properly. Now, whether or not any situation can be 100% safe, I agree that that's not likely. But I don't think sorry, go ahead. I apologize.
No, because you say it's a reasonable statement for an escrow service. So I'm trying to determine, if there was no escrow service, would this be a statement that would lend a user to believe that they were dealing with an escrow service?
So if in this hypothetical situation, if the seller was sending the Bitcoins directly to the buyer, and they had reservations about whether or not the money would show up, this neutral party that is neither the buyer or seller telling the seller everything will be okay, just send the Bitcoin, would that be a reasonable thing to say, and would that sway anyone? No, in that situation, I don't think it would do it. But again, that is and I've mentioned this before, you know, that escrow service taking on that risk allows them to make that claim that it will be safe. If they're not involved, then for them to say everything will be okay, I agree. It's not, there's no weight behind it. But if they are in that position and where they are trying to take on that role, assume that role as an escrow service and help that transaction take place, then for them to assure someone that things will be safe, I think that's something that, you know, whether or not it's naive, still is something that's supposed to give calm to a party, and thus it does have weight.
You just, in what you've just stated, that you're saying that the escrow service taking on that risk allows them to make that claim. Do you think that taking on that risk requires some sort of agreement for an escrow service?
I'm gonna have to go with I'm not a lawyer on that one.
Okay, that's fine. Now, your main conclusion on all these points regarding assurances and how they were unreasonable is basically that by including the buyer in the key system, there was a significant compromise to the security of the wallet. Is that right?
Correct.
So you repeat this in paragraph 55, 56, 57, 58. It's the same language. By including the buyer in the key system, there was a significant compromise to the security of the wallet. But again, this doesn't really comment on how the inclusion of the buyer was on advice of the second defendant or by TABARAK, does it?
No, it doesn't comment on that.
And in paragraph 59, you state that the requirement to transfer the Bitcoin to the wallet prior to the availability of funds was not out of the ordinary for an escrow service. Is that right?
Correct.
In the joint memorandum, as you'll remember, it actually says the opposite, that in order to have a secure transaction, funds should be transferred before coins are transferred. Can you reconcile those two positions?
I think they both represent adequate levels of security, but again, theoretically, if the escrow service is doing an effective job, it doesn't matter which one comes in first. The experts agreed together that one was, you know, marginally more secure, but I personally also believe that again, if that escrow service is doing things properly, the order in which they come in should not really have any sway in the safety of that system overall.
But I think you can appreciate that having the funds outside of the exclusive control of the buyer, for example, in TABARAK's bank account or in a third-party bank account, would decrease the risk of security for a transaction.
Well, not if those assets are both being held by that same neutral party. And if we believe the neutral party is good and doing their job, then, you know, we should agree that in a normal situation, the buyer and seller both has an equal opportunity to be bad.
Mm-hmm.
So the fact that, you know, dollars can come in or Bitcoin can come in first to this central neutral party shouldn't really affect the security of that transaction, because it's not always the buyer who is trying to steal Bitcoin. It is not always the seller trying to steal dollars. We don't know what's happening in this situation. It's up to that neutral party to take in both, make sure all those conditions are met, and then the funds can be transferred out. Now, one side might prefer that they put theirs in second, but I don't necessarily see how that adds a significant change to the security composition of the system.
Do you think it adds a significant change to the security composition of the system if the coins are sent directly to the buyer's wallet?
Yes.
And do you think that do you think it adds a significant change to the security composition of the system if the seller and the buyer detract from the proposal presented by the neutral third party? And by detract, I mean deviate.
I mean, certainly in this case it did. So again, I can't, it's hard to argue the opposite to that. But it's, you know, it has been my experience that things can change, and they often do change quite quickly sometimes in the cryptocurrency realm. So it's not completely out of the ordinary that terms and protocols can change. But again, I would agree that that central party trying to hold custody of these assets to help facilitate this exchange, you know, they might change the protocol last minute, but ultimately it's their risk and their comfort and their business case to make those changes.
Thank you. I have no further questions, my lord.
Thank you very much. A re-examination, please.
Sorry, did I freeze up again?
No, that was me. No re-examination, thank you.
No re-examination. Thank you very much. Now, when do we normally take the half-hour break? Let's ask the transcriber. Mrs. Transcriber, we go on until 2 o'clock London time, and it's 20 to 1 now. Would you like half an hour now so that we would resume at 1:05, and then we continue round till 2 o'clock? I think there may be scope for a short break during the continuance, but what we're talking about now is the half-hour break.
That would be fine, thank you, sir.
At this moment, half an hour now.
If that's possible.
It is possible. Yes, it is possible. So that's what we'll. Yes, please, Mr. Joe. Yes.
I'm just wondering who do we actually have left? Because I think there's just a little bit left to go on Mr. Malik. Yes. In which case,
Mr. Popper has to be.
Yes.
And who?
Mr. Popper, the second defendant's expert.
Yes.
So the question is, are we going to finish off Mr. Malik or start
so that he can? Well, I would very much like to finish the expert evidence.
Okay.
So after the half-hour break, we would have the last expert witness and strive to complete his cross-examination and re-examination during this session.
Mm-hmm.
And much will depend on how it goes, but that must be our ambition, because there is no way this trial is going to go into a day beyond Sunday. We're going to sit on Sunday, but we're not sitting for any further day after Sunday. So that's how I think we ought to proceed. It makes more sense that we've had expert evidence all through the day, and it makes sense to finish with the expert evidence today if we possibly can. And then we'll hear Mr. Turner on Sunday, and we'll agree a timetable for the submission of written representations. So we'll take, we shall resume at just after 5 past the hour and go through until 2 o'clock. Well, we may go a little longer depending on how the transcriber's going. If we can finish it off with an additional quarter of an hour, then that's what we'll do so that we can finish expert evidence today. Okay?
Thank you, my lord.
Right. So just after 5 past the hour, we shall resume. Thank you all very much. Well, are we all ready and correct?
Yes, my lord.
Okay. Well, we'll have the same procedure for your witness.
Yes.
Elicit his name and his address, and then pass him over to me, and then he comes back to you to confirm the signature, and he's vouching the truth of what he says. Okay.
Mr.
Right.
Popper, good afternoon. Could you give us your full name and your address?
Sergiu Popa, I currently reside in Bucharest, Romania.
Oh, there he is. I guess it's about, it's still in the afternoon in Romania, Mr. Popper.
It's actually 3:09 past the
It's
hour.
3:09. It's an hour ahead of London. Fine. Have
Actually,
you given evidence before as an expert witness?
yes, I have.
Fine. Well, I'm going to ask the second defendant's counsel just to have you identified yourself, and then I shall administer an oath and ask you to make an affirmation, and then you'll be shown your witness statements, and then you'll be cross-examined. You'll be aware of the usual procedures. So, Mr. Matthew.
Thank you, my lord. Mr. Popper, please could you go to 10253?
Yes,
Is this your expert report?
that's correct.
Please could you turn to page 10266 of your expert report?
Yes,
At the bottom of the page, do you confirm that this is your signature?
I do.
And you confirm the contents of this report are true to the best of your knowledge and belief?
Yes.
Now, Mr. Popper, every witness taken a religious oath or having made a secular affirmation as to the truth of what is being said. What is your choice, to take a religious oath or to make a secular affirmation?
A secular affirmation would suffice.
Good. Now, I'm going to ask you a question, and I shall be expecting the answer yes, but it's up to you. Do you sincerely, solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth, and the opinions that you state are your honestly arrived at opinions?
Yes, Your Honor.
Thank you very much, Mr. Popper.
Mr. Popper, so I'm Ms. Stewart, counsel for the claimants. As I think you know, I think you've been sitting in on most of this trial, yes?
At the very beginning, just at the very beginning, I sat in.
Okay, all right. Right, first thing I'd like you to tell me, there's been some reference to clicking in throughout the evidence, clicking in relation to when the mnemonic is set, right? Can I just clarify, do you agree that the Trezor device is a touchscreen device?
I do agree it's a touchscreen device. It's actually an IT85 microcontroller composed of an LCD and a cryptographic module.
Okay, so there's no separate button that you actually, on the side of the device, that you actually click?
No, it's a touchscreen device. That's how one interacts with the device, by clicking on the screen on the LCD.
Yeah, but you don't hear a click.
You don't hear a click, that's absolutely correct.
And when you're going through the recovery seed setup, is it correct that you see 4 words at a time on the Trezor T model?
Actually, you see 3 at a time or 4 at a time, depending on the model and the LCD screen. Some of them, there are models of the T where you see 3 at a time. There are models of the T where you see 4 at a time. That depends with the length of the screen, with the capacity of actually showing those to actually display those.
Lovely, thank you. Right. Now, you've said in the, you've agreed in the joint expert memorandum that the Trezor device was intended to be utilised as a mechanism for ensuring that the Bitcoin were not exclusively controlled by the buyer nor the seller until the US dollar was paid into Tabarak's bank account. And also that once the funds needed for the purchase of the Bitcoin were confirmed in an accessible bank account, the Trezor device could either be used to craft a transaction which transferred the Bitcoin to the buyer's own wallet, or the buyers could accept receipt of the Trezor wallet itself. Yep, do you remember that?
Would you be kind enough to refer to me to where I made that statement? Because the only thing that we did agree upon in the expert report was that we would talk about the circumstances pertaining to the day of the transaction and how the Trezor was used. But could you please refer to me to my statement?
Yes, absolutely. This is the joint expert report. Sorry, I should have taken you to it. I just thought it was going to be familiar to you. Right. If I can take you to 10-3.
What's the exact code? 10-3103. Okay. All right. On what precisely, which paragraph?
Okay, so right at the top of that page, there are 2 paragraphs.
What is Bitcoin? That's one of them, right?
No, this is 10. So sorry, this is 10-5. I think the tiredness is getting to me.
Okay.
10-5.
Yes, exactly. That's what we stated. That's what we agreed upon in the expert report.
Mm-hmm. Thank you. Now, you would agree that the Trezor wallet on the 3rd of February, it was supposed to be set up in such a way so to ensure from HUOBI's perspective that the Bitcoin transferred to the address associated with the wallet couldn't be transferred to the buyer before the buyer's funds were received in Tabarak's bank account. Yes?
No, what we agreed upon was that on that day, a third party should have set up the wallet because the whole procedure.
What do you agree upon? Do you agree that the purpose of the transaction was to ensure that the Bitcoin transferred to the wallet address associated with the Trezor couldn't be transferred to the buyer before the buyer had paid for the Bitcoin?
Yes, if the wallet is set up correctly, that's correct. If the wallet is set up correctly.
Thank you. So, and therefore you'd agree that if the buyer didn't pay, that the assumption would be that the Bitcoin would be sent back to HUOBI unless there was any other kind of agreement. Yeah. So we've got this assumption that you've accepted that neither the buyer nor the seller should have control, and you've accepted that in the event the buyer didn't pay, the Bitcoin was to be sent back to HUOBI. That would be the natural assumption, yeah? Yes. Okay. So as a matter of logic, the only way this could have worked is if Tabarak did in fact have complete control, sole control of the Bitcoin in the address.
This could have worked if the wallet was set up properly, either by Tabarak or whoever else they would have chosen on that specific day.
And that would have required Tabarak to have exclusive control of the Bitcoin in the address.
I don't want to speculate because from my point of view, there's no escrow agreement, so I don't interpret Tabarak as an escrow agent. Therefore, anybody present in that room who had the proper knowledge to set up the wallet, understanding the security protocols, they could have done so. So I don't know exactly who was
No, that's not
responsible
what
to
I'm
set up.
asking you. I'm asking in this scenario, in order for the Trezor wallet to fulfill the function it was intended to fulfill, the only way that could happen is if TABARAK had exclusive control of the Bitcoin associated with the wallet.
Probably, yes, probably.
Well, yes or no?
Oh, I think that's good enough. That's
Okay.
yes, really.
Right. I just want to check that you agree that the verification process is actually a mandatory step in the setup of the wallet.
I'm sorry, could you repeat the question? The verification process is what? I'm sorry, you're breaking down. That's why I'm asking twice, because you broke down.
Oh, sorry. Is anyone else having trouble hearing me?
Okay. Let's have another go.
Okay. Okay. Could you therefore go to 10-281?
Okay. On correction number 3, is that correct?
Yes, so this is about the verification procedure. You've read this.
Yes.
And do you agree that this verification step is a mandatory step? It
Yes.
must. Okay, thank you. And would you agree with the description at paragraph 32 of what this process involves, as described by the Trezor manual?
I do agree with the exception that there are not there are exactly 3 words that you're being asked to choose from the set of 12, which are randomly chosen by the VIP 39 protocol.
Yeah. And would you agree that, okay, someone had to carry this out, and would you agree that whoever did carry it out is more likely than not, so there was a greater than 50% probability that that person had access to all 12 words of the mnemonic?
That's one of the scenario in breach vector 3. That's not my hypothesis. I support breach vector 4.
No, I'm not asking. I'm asking a completely different point. I'm asking that if the person, somebody must have carried out this verification process, yeah?
That's true. That's true. That's absolutely true. Yes.
And what I'm asking you is whether you agree that it's more likely than not, from a statistical perspective, that so there's a greater than 50% chance that the person who carried out the verification process had access to all of the 12 words.
That's precisely correct, with the one clear specification in mind if they actually went through that procedure. Because if the wallet is actually tampered with, they don't need to go through that procedure. But mathematically, yes, and the way the probability is actually derived, it's quite simple.
Yeah, great.
Actually 1911.
Yeah. I'm not sure I found it that simple when I was going through it last night, but
it's quite easy. Binomial coefficients of all the probabilities, and then the way you choose from the 2 subsets.
Yeah. Okay. Right. Now, moving on to the PIN code. Do you agree that the setting of this PIN code is a recommended, but it's not a mandatory step?
It is recommended indeed, but it's not mandatory.
Thank you. Now, after the joint report came in, the claimant solicitors wrote to the second defendant's solicitors pointing out about the issue about the PIN code, but you at no point have you corrected your report to reflect the
There was. I'm sorry. I apologize. Please go ahead.
No, carry on.
Well, there was no relevant issue whether a PIN was set or not, because as you have previously stated, it's advisable for the security of the transaction that a PIN code is set, but it's definitely not mandatory. And the firmware of the Trezor wallet does not impose upon the proper operation of the wallet for a PIN code to be set.
Well, with respect, I would suggest that in the context of what the judge has to decide, it is relevant. For example, let's assume that the buyer had not tampered with the device, first assumption, and then let's assume that the buyer wasn't able to or didn't record the entire mnemonic, right? Those two assumptions. Now, it's not disputed that TABARAK had possession of the physical device because everyone agrees that it was locked in TABARAK's safe. Therefore, it follows as a matter of logic that TABARAK had control of the Bitcoin in the address if either no PIN code was set, which was a possibility, which was an option, or a PIN code was set and TABARAK knew that PIN code. Do you agree with that proposition?
No, because if we were to go by the hypothesis which you just postulated, then that would mean that they would also have to have access to the second subset of the 6 words that were in the possession of the buyers. If we were to construct that argument symmetrically in logic.
Don't need the recovery. If you have the physical device and the PIN code, or just the physical device when no PIN code has been set, you have control and you can transfer the Bitcoin in the wallet.
You're absolutely right. You only need the recovery passphrase in order to recover and to access the wallet remotely. But if
Exactly.
if you have it in your possession and you have no PIN code, you may operate it. Yes, that's absolutely precise. I just wanted to make sure that we're on the same page with the assumptions.
No, absolutely. Right. Now, and it would be fair to say that if the security of the Trezor wallet hadn't been compromised, and TABARAK had exclusive control over the Bitcoin, then this would have been a safe way of conducting the trade, because the Bitcoin could have been sent back to HUOBI if the buyer hadn't paid for it.
I would assume that would have been the case, yes. I mean, if everybody's intentions were to be what they stated they were, yeah.
Thank you. Now, it's ultimately going to be a matter for the court to decide whether there was an intention to provide an escrow service and whether an escrow service was actually provided. Now, but what I'm going to put to you are various actions which I'm going to ask you to assume were carried out by TABARAK, okay? And I'm going to ask you to accept whether those actions that I put forward are consistent with an intention to provide an escrow service. Okay? So it's going to be straight yes or no. And it's going to be for the judge to decide whether advice was given or whatever. Okay? So, first of all, Mr. Thurner when asked by the claimant whether he had any concerns about the buyer's Trezor, said no. Is that consistent with Mr. Thurner providing assurance about the safety of using the wallet?
You're asking me to answer the question with a yes or no, but Mr. Thurner is not a security expert. He's not a Bitcoin expert. So
No, I know your position on that. It's straight yes, no answer.
I simply cannot answer that question because I don't know if everybody accepts that they're fine with it. Then yes, I would guess the answer would be yes.
The fact, and I think this is agreed between the parties, that Mr. Thurner reviewed the packaging of the Trezor devices for signs of tampering and authenticity. Do you agree that that would be consistent with providing an escrow service?
No.
So the fact that he took an active role in checking that the device hadn't been tampered with, and you're saying that is not consistent with an individual providing some kind of checking for the integrity of the device?
No, and I'll give you my reasoning for that if you wanted.
Yes, please.
Mr. Thurner is not really qualified to determine whether the hologram on the device it's actually authentic or not. I'm sorry, I'm just going to make a brief introduction. I possess a doctorate degree in mathematics in differential equation with a high specialty in other subjects such as physics. Okay, so whenever it comes to holography and the science of actually counterfeiting holograms and counterfeiting Trezor wallets, this is one thing that I know about. And I have served various positions with the intelligence departments within the United States and some other positions which I'm not at liberty to discuss. So I have seen on a couple of occasions, I have seen cases where the hologram itself could be faked. Hence, Mr. Thurner, with all due respect to the court, is not capable of determining whether it's a genuine device or not. Hence, from that point of view, that's what motivates my answer, that it wouldn't qualify him as an escrow.
Right, I think we've got you on that. Okay. The fact that Mr. Thurner provided his own laptop device for the purpose of initialing the Trezor device, that was consistent. Consistent, not determinative, but consistent with him providing an escrow service.
No, I don't agree with that either. I agree with the fact he provided his laptop, but I don't agree with the fact that constitutes providing an escrow service. But that's my personal opinion on the interpretation of escrow. I
didn't say it constitutes, I said it's consistent with.
No, I don't agree that that's consistent with the fact that he provides escrow just because he's provided his laptop.
Right. Okay. The fact that Mr. Thurner was directly involved in the key creation process during the initialization, that's consistent with him providing an escrow service, isn't it?
Partially.
Thank you. And the fact that Mr. Thurner and Miss Saviolova, they wrote down 6 words of the mnemonic, and then they handed the wallet and the laptop to the buyer for the purpose of writing the other 6 words. If they did that on the assumption that they thought that the mnemonic, that the entire 12 words would not be disclosed to the buyer, would you agree that that's consistent, not that it constitutes, but it's consistent with providing an escrow service?
Partially.
And the fact, and I think it is agreed, that Mr. Thurner confirmed to HUOBI that the price proposed for the Bitcoin was accepted by the buyer. That's consistent with providing an escrow service.
Again, from my point of view, just partially.
Thank you. And if, I'm not asking you to say whether it's true or not, but if Mr. Thurner assured the claimant that it would be safe for the claimant to transfer the Bitcoin to the Bitcoin address before the buyer had made payment, that would be consistent with providing an escrow service, wouldn't it?
No, no, and I could argue that point as well.
Okay.
Yes, would you like to tell us why you think that?
Yes, Your Honor. The reason for that is because most of the time in an escrow agreement, whenever you're dealing with, especially whenever deals are made in an OTC transaction, a contract has to be specifically drawn to indicate what are the responsibilities of the parties involved in that transaction. As you could see from the case, this is all chaotical. Nobody has decided anything. And second of all, the main flaw in the whole security protocol of the procedure is the fact that the buyer provided the wallets themselves. Hence, nobody could attest to the integrity, the forensic integrity, especially of the firmware or whether the device was genuine or not. So how can the term escrow even be brought into the agreement? I read the expert's report. I think it was Mr. Joshua McDougall's report, where he tries to build an isomorphic argument by trying to map specific parts of the actions that were taken that day to specific parts of what we come to deem by common vocabulary to an escrow transaction, but that's far from being the truth, in my opinion. Hence, the simple fact that Mr. Thurner tells somebody orally or whichever way, in whichever manner of communication, that this transaction is safe, that doesn't mean anything. It does not constitute an escrow transaction.
So you're saying that, as I understand, the fact that Mr. Thurner assured the claimant that it would be safe for the claimant to transfer the Bitcoin before the payment had been made, that you're saying that was not consistent with an intention to provide an escrow service.
It was probably consistent with what people perceive to be an intention, but whenever we say the word assure, how did he assure them?
The fact that if Mr. Thurner assured or told the buyer that the Bitcoin had arrived in the wallet, that would also be consistent with an intention and a perception that Mr. Thurner was providing an escrow service.
You could view it that way, yes. You could view it that way in case all the interests of everybody were to be legitimate at the table.
And an assurance by Mr. Thurner to the claimant that the buyer had sufficient funds in Dubai to complete the transaction, that would also be consistent with an intention or a perception that Mr. Thurner was providing an escrow service.
No, I don't agree with that either. But I'm not a compliance expert in terms of what constitutes to be considered escrow in UAE. So I don't know. I'm not qualified to answer that question. But logic would imply that yes on one hand, but then on the other hand, again, from my point of view, this was no escrow deal whatsoever. So my answer is no. My answer is no. My final answer.
And the fact that after the Bitcoin was transferred to the Bitcoin address, that Mr. Thurner stored the wallet in TABARAK's safe, not disputed, that is consistent with an intention to provide an escrow service. Would you agree?
I would agree, but I want to mention one thing again. If we take a look at the line of reasoning from the expert's perspective to where we're trying to map arguments which map the actions that transpired that day, that took place that day, to what an escrow transaction actually means.
And
there's one, I'm sorry, there's one more thing that I wanted to mention. Who was in the possession? I mean, the buyer brought the wallet to the table. So that breaks down the whole deal right then and there.
If you don't mind, I'm asking the questions. Now, the fact that Mr. Thurner checked whether the buyer had transferred the payments to TABARAK's account, would you say that that is consistent with a perception and an intention by Mr. Thurner providing escrow services? Would you agree?
If you take it out of the context of that day, yes. Pertaining to that day, no.
And the fact that TABARAK was, on the assumption that an agreement had been reached as to what TABARAK would be paid.
Sorry, carry on.
As to what TABARAK would be paid as a result of providing services on that day, that payment, and the commission alone was over $7,000, that is consistent with the provision of escrow services.
It could be, yes.
Now, it's your client's position that
well, hang on a moment. I made this point, I think, to Ms. Alma. The second defendant is not this witness's client. This witness is giving evidence on behalf of the second defendant, but he's giving it as in an objective and neutral way. He's not here to advocate a particular position on behalf of the second defendant, as we all know. So if you could just tweak that a little bit, I would be grateful.
I will do. So the the three experts, including you've agreed that the definition of a neutral venue is a space for parties to conduct the OTC transaction. When a neutral venue, whether a coffee shop, office, or another venue, acts as a neutral venue, their role is to do nothing more than provide space unless additional arrangements have been made with the neutral venue, so as to have them act as more than merely a neutral venue.
Correct, that's correct. That's what we stated. Yes, we agreed upon that.
Now, you would agree, would you not, that the list of actions that I have just set out, the many actions, they go well beyond just providing a space to conduct the OTC transaction?
No, I wouldn't agree with that.
You wouldn't agree that all of those actions?
No, because again, according,
space.
no, and the reason for which I don't agree with that, I have taken place in various, countless OTC and I would say escrow transactions, and they never transpired in the way the events on that day took place. So they're completely incongruent with what I'm used to. So no, from my point of view, no.
But Mr. Popper, it's clear from the evidence that Mr. Turner participated in one way or another in the implementation of the transaction. He checked the wallet to begin with. He had a hand in the 6-word mnemonic and so on. Now, don't you accept that that's beyond merely making available the space for the parties themselves to transact, to implement the transaction?
I would agree with you, Your Honor, from a syntactical point of view, that he actually did more than he was supposed to do from the point of view of a neutral venue. So yes, I would agree with that.
Okay.
Thank you. Now, it's going to be a matter for the court to decide whether TABARAK, Mr. Thurner, was responsible for advising or implementing a process for a safe transaction, namely one pursuant to which the Bitcoin couldn't be transferred to the buyer before the buyer had paid. And it's also going to be up to the court to find out whether TABARAK / Mr. Thurner held themselves out as being able to provide that type of service, those types of services. However, what I'd like you to do is to consider a scenario in which the court finds, one, that Mr. Thurner was responsible, or TABARAK was responsible to HUOBI for advising on implementing a process for a safe transaction, and two, that Mr. Thurner held himself out as being able to provide those types of services. Now, in that scenario, would it be fair to say that your view would be that the process used was not safe? I have to ask you this question. It may seem blindingly obvious, but I'm just asking you this question.
Well, the answer is trivial. Yes, obviously. Yeah, considering those scenarios.
Yeah. And would it be fair to say that in that scenario, your view would be that any advice given by TABARAK / Mr. Thurner to the effect that the process was safe and was not the standard that you would expect of an investment bank which held itself out as being capable of providing those services?
Was the actual question, I'm sorry though, because was this still a speculation on the scenario, or was there an actual question?
Yeah, so the scenario is still TABARAK and Mr. Thurner are responsible for advising and implementing the process, and two, that TABARAK and Mr. Thurner held themselves out as capable of providing these services. So the question is whether you agree that in that scenario, any advice given by Mr. Thurner / TABARAK to the effect that the process was safe was not the standard that you would expect an investment bank who hold themselves out as being able to provide these services.
Yes, you're absolutely right. I wouldn't.
Your Lordship, there's a whole line of questioning which I could go down about expected knowledge and actual knowledge. I've covered it all in my cross-examination already of D1's expert, and so given your previous indications, I'm reluctant to do the same again. I'm not sure it's necessary.
I mean, ultimately the decision is yours, but my intervention was fairly clearly expressed, and So I'm not surprised that you would choose to take the course you're going to take.
I'm grateful. Right, now could you go to 10.265?
Just give me a second. Yes.
The last point on that page, which is the point about the blockchain, shows 35 Bitcoin which recycled back into HUOBI's network.
I'm sorry, page 10.265 does not show that. I'm actually in my
10.265?
13, right? Okay.
Yeah.
Okay.
Yeah,
I
little
found that, yes.
Roman 13. Yeah.
Yeah, Roman 13, correct.
Yeah. And you're asked a question here, and the beginning of that says that the blockchain shows 35 Bitcoin cycled back into HUOBI's network. By HUOBI, do you mean, is what's meant here and is how you've interpreted it, HUOBI Global?
Yes, HUOBI MENA out of Dubai, they piggyback on the APIs on the application program interface of their main network. So that's why I made that statement.
Okay, but you're not, are you assuming that HUOBI MENA or HUOBI OTC can dictate what HUOBI Global does in relation to Bitcoin held in the HUOBI Global, on the HUOBI Global exchange?
No, I'm not making that assumption. The reason for which I made that statement is because there is a specific degree of cooperation from all the, first of all, from the compliance department, from the software that they use. For instance, one of the software that was mentioned throughout this trial was chain analysis, Reactor, right? They should have had access to that, and in fact they did, to actually know that those 35 Bitcoins did cycle back. So it was a natural question that presented itself whether the 35 Bitcoins were actually reinforced by KYC procedures. That's why I asked that. But I did not make the assumption that the main HUOBI main was going to cooperate.
So when you say that it is to be concluded that the claimant could have recovered the 35 Bitcoin by enforcing KYC/AML, that's contingent on the assumption that HUOBI Global would have cooperated.
That's right. That's precisely correct. That's precisely correct.
Thank you. I'll just check with those instructing me if there are any further questions. Sorry, it's the disadvantage of not being able to just turn around.
Yeah.
No further questions.
Thank you very much, Ms. Stewart. Ms. Ahmed?
Yes, thank you. Mr. Pocock, a question was put to you by Ms. Stewart as follows, and I'll very quickly remind you of the question. It was when a scenario was being presented to you that Tabarak and Mr. Turner are responsible for advising and implementing the process, one, and two, that Tabarak and Mr. Turner held themselves out as capable of providing these services. So the question was whether you agree that in that scenario, any advice given by Mr. Turner to Tabarak to the effect that the process was safe was not the standard that you would expect an investment bank who hold themselves out as being able to provide these services. Now, putting aside whether or not they in fact held themselves out to provide those services, Would you expect an investment bank to be providing these services on its own?
No, if they're not qualified and they don't have that in their profile to deal with the cryptocurrencies. But again, this is a very unusual situation because in OTC transactions, everybody pretty much, they could define their own protocol because the standard procedures that have been mentioned throughout this trial, the cryptocurrency standards, they're advisory, they're not mandatory. So whether the parties that are present in an OTC deal adhere strictly to these rules, for the lack of a better word, I guess it lends itself available to their mental faculties, whether they choose to follow those or not. And I don't mean this to come off as a joke, but I mean the whole thing has been, kind of funny from that point of view.
And Mr. Pope, you were taken through a series of questions about acts undertaken by Mr. Turner, which may or may not have been consistent with providing an escrow service. And I just want to sort of revisit some of those acts that you were taken to. One proposition that was put to you was that Christian Turner was directly involved in the key creation process, and therefore this would have been consistent with the intention and perception of providing an escrow service. And you said partially to that question. Can I just ask how?
Why did I say that partially? Because you see, I have the curse of being a mathematician. So whenever it comes out to epistemology, the science of how the truth is the truth, then there's not a logical tautology whatsoever by the way that question was phrased. So basically, yes, he did show intent of setting up the wallet. Did he do it in an adequate fashion, or did he do it in such a fashion which would further facilitate escrow services? No. The answer to the second question, no. Did he actually try to help them out? Yes. Was it because it resembled an escrow deal? No. So that's why I said partially. I hope this makes sense.
Yes, thank you. And you also, in response to a question that was put, and I'll go back to the question, which was, in writing, Christian Turner, in writing down the 6 words of the mnemonic phrase, handing the wallet and the laptop to the buyer, these were acts that were consistent with providing escrow services. And again, you said partially. Why?
I think I said no to that question. I don't think I said partially. So partially within the context that everybody's intentions were genuine, yes, I would answer partially. But according to what transpired, I say no. Yeah, well, the procedure of so the whole complete procedure from a security standpoint, it's flawed. You may not transfer words. You may not. Only one party is supposed to hold the passphrases to those. And there's another thing. The Trezor wallet itself does not store the passphrases, though. It stores a hash key to the passphrase. That's why you're even being asked to recover those. So when I had the joint expert meeting, the reason for which I proposed in the first place a 4th breach vector was for the following reason. In the evidence that I analyzed, I haven't seen that the buyer actually held down their hand on the button. There was no indication of that to confirm those words, because technically speaking, whenever you confirm the subset of 3 words, you're supposed to hold down the button on the word for 5 to 10 seconds. And that's why I excluded that breach vector in the first place, because I personally believe that nobody confirmed those 3 words. That's my belief. And I have seen cases like this with the Interpol and the Europol in Europe. Okay.
You also gave a response to a question that was being asked about sort of the common vocabulary deemed in escrow transactions. What were you referring to when you talked about the common vocabulary to an escrow transaction?
I'm not an expert. I'm a cybersecurity expert and a blockchain expert. But usually, whenever an escrow transaction takes place in the cryptocurrency world, it's being defined by a contract. There has to be an escrow contract that shows exactly who assumes what roles. By the simple trivial implications of the fact that the roles which are imposed on that day simply imply that this should be a escrow transaction, in my opinion, again, that's the reason for which I keep on stating it's not an escrow transaction. Because the common vocabulary, who sets up, who set up the wallet? So we have the word wallet that constitutes the universe of discourse, right, of this conversation. And what else do we have? The custodian. So who's the custodian in this case?
And you were also asked questions about the intention and the perception being consistent with an escrow service. And it's right, you can't really speak to anybody's intentions or perceptions, can you?
Obviously not.
And you also, in response to a question, said that because the buyer brought the wallet, this breaks down any escrow service type arrangement. Why did you say that?
For the following reason. So, for instance, in my expertise, I have tampered with the Trezor T wallet on various occasions. So the way it actually works, you actually rebuild the firmware, you recompile the firmware. So if the buyer brings the wallet to the table, there's a concept in computer hacking called a reverse shell. So the moment that wallet gets connected to any TCP/IP inbound connection, the whole key phrase is being sent on a remote terminal. Hence, you don't need, you could fake, you could social engineer the whole procedure. That's why I said that. That's why I'm clearly making that statement over and over again, restating that, because if you're bringing the wallet, you have no knowledge whatsoever unless you do a forensic integrity check of the firmware, whether that wallet is genuine or not. That's why I said that breaks down the whole procedure, because in an escrow transaction, the wallet should be brought by the party that's being trusted, by the third party. And that third party should never disclose the location or the acquisition means of the wallet. This happens in supply chain attacks and in other government services, which I won't go into, but normally only the third party is supposed to acquire the wallet and not disclose to anybody whatsoever any details about the purchase, because then you could have a man-in-the-middle attack.
You were also asked a question whether the fact that Mr. Turner checked whether the buyer had transferred the payments to TABARAK's account, would you say that that is consistent with a perception and an intention by Mr. Turner providing escrow? You were asked to agree with that proposition, and you said if you take it out of the context of that day, pertaining to that, yes, pertaining to that day, no. Can you just clarify and elaborate on that answer, please?
Well, again, and this resumes to to one simple sentence. If the simple fact that Mr. Turner offered himself to help out, sort of speaking, right? Whether that happened for a fee or not, for the technical purpose of the question and the transaction, that's irrelevant in the technical aspect. So, did he provide escrow services just because he managed to check the account? Couldn't the computer version of Raspberry Pi have done that? I mean, everything that that took place that day, right, could have been fully automated on a computer. So you do get my point, right? I mean, there was no point whatsoever. The simple fact that he checked and he said whether there are funds available or not, there's just the reassurance of the fact whether the funds are there. But if there are no further steps to be implemented once this is checked, then how is that an escrow transaction?
And again, you were also asked the question about whether a payment of commission in the region of 7,000 will be consistent with providing escrow services. Now, and you said could be, but isn't it the case that that payment, if in fact it was agreed and if the court finds that there was an agreement for that payment to be made, could that not be payment for providing the venue? Pens, pencils, water on the day. Why is it consistent with an escrow service?
If you allow, yeah, for that small amount, I would say that yes, just to provide a space.
And you were also asked a question, and your response was that you know, you've been involved in a lot of OTC transactions, and what happened that day was incongruent with what a normal OTC transaction that you've been involved in. And the judge postulated, well, Mr. Turner was a participant, he checked the wallet, he went beyond making available the space. But what do you say about what Mr. Turner did in terms of checking the wallet and going beyond making just available the space that could be described as being incongruent with the OTC transactions that you've been involved in?
So what I want to clarify, everybody should have stopped the moment that the buyer brought their own wallet to the table. Everybody should stop at that point. That's the first incongruency that we find within this transaction, because nobody present in the room, according to what I've seen so far, is capable of determining whether the Trezor was a regular Trezor or not. And none of the steps, some of the steps, I would say, let me rephrase that. Some of the steps would perhaps make an allusion to the fact that this closely resembles to an extent an escrow transaction, but from a security standpoint, it's no escrow transaction in any matter whatsoever. I hope this answers your question.
Yes, thank you, Mr. Booker. I don't have any further questions. Thank you.
Thank you.
Thank you very much. Re-examination.
You're muted.
I'm not.
My lord, thank you. We have
yes.
no questions for re-examination.
Right, thank you very much. But Mr. Popper, it remains for me to thank you for making yourself available and for your evidence. That will conclude the proceedings for today. You are released, Mr. Popper.
Thank you, Your Excellency.
And we shall resume on Sunday. We will finish Mr. Malik, which I anticipate won't take very long. And then there's Mr. Turner. And this must be concluded.
And sorry, forgive me, my lord, and Ms. Zaviolova as well.
And Ms. Saviola. And Ms. Saviola, you're quite right. You're quite right. But these are going to have to be done in the time. Now, maybe this is a case where counsel for the three parties should put their heads together to draw up a specific timetable for how Sunday proceeds, because there is going to be no further evidence taken in this trial after Sunday. Now, I would propose that we begin on Sunday at 8 o'clock instead of 8:30 London time, but we spend the same number of hours as we would if we were starting at 8:30. It's just that we get off, we take off half an hour earlier. Now, there will be very limited flexibility as to whether we go beyond the normal allotted hours. It would only be to a very small extent. So please work out a timetable between you as to how long each of you is going to take with these two witnesses. It does seem to me that at this stage in the trial, when there's been a pretty detailed investigation through the questioning into all the aspects of, all the factual aspects of this trial, that we ought to be able to complete these two witnesses comfortably within the same period of time, but starting at 8 o'clock. So I ask all three of you to see what you can do to cooperate to achieve that outcome. So with those mandatory words, I will draw this session to an end. I look forward to seeing you on Sunday morning. Thank you.
Thank you.
Thank you.